At least. ডেটটা দিয়ে দিন টিউসডের question.
Your Lordship.
Yes.
Your Lordship, may I mention a matter, Your Lordship? I had already mentioned on Monday for extension of interim order, Your Lordship. The interim order is expiring tomorrow, Your Lordship. This is the urgency, that's why I'm mentioning it again, Your Lordship.
Why are you mentioning? It will appear if it's mentioned on Monday. It will appear tomorrow. Yes. Some have been placed today, some will be there tomorrow. It will be there. Why are you mentioning again? If you have not mentioned it, then mention it.
No, Your Lordship, I had mentioned
will
on
be
Monday, Your
appearing.
Lordship. Lordship.
Similar matter, my lord. It will be appearing tomorrow. Some of the matters have directed to appear today, some will be there tomorrow.
No, Your Lordship, I was being told that the file is not there in the department. Something, there's some issue.
It is a different issue. Find
Your
out.
Lordship, may
Find out.
direct the department to list.
Find out where the file is. How can I direct?
Your Lordship, we tried, Your Lordship. but-
Ascertain from the department. Yes. Have you mentioned earlier? It will appear. Why are you mentioning today? Yes. Any other mentioning?
Lordship,
If someone has not mentioned the matter, not handed over the slip, then mention and hand over the slip. Otherwise, do not mention. Yes, very well, madam. It will appear. Yes. So you will not be there tomorrow. Very well. Any
this
other
matter
mention?
was mentioned, my lord, on Monday. Lordship has directed me to mention on Thursday. My lord, relating to expiry of evadable covered matter, my lord. No intention to evade has been recorded. Direction for affidavits was given in 2022, my
No
lord.
affidavit has been filed.
No affidavit is forthcoming, my lord. Matter can be taken up. It's covered by judgments of the division bench as well as your lordship's own judgments,
I
my
have to consider this.
Hello?
I have to consider your matter.
Yes, my lord. May I hand on?
এটাকে
I have served, my lord.
adjourn করে দিয়ে দিন। No affidavit has been filed.
No affidavit has been filed. I have given the order. I have served.
Adjourn motion করে দিন। Monthly list. Adjourn motion after the motion.
I'm grateful.
This is Madam. The order was passed by Honorable Justice.
Wait a minute, one matter is going on. I have not completed that. देखी दिन. Where is the order? Did you mention before 18th? Was this order brought to the notice of this court? Did you mention before 18th of May, madam? When did you mention it? Where is that notice? হিয়ারিং এ দিয়ে দিন এইটা শুধু You must be in a position to demonstrate with that slip. এটা ফেরত দিয়ে দিন। This is in December. You did not mention in time, madam. This is in February. এটাও ফেরত দিয়ে দিন। You have to wait, madam. Mention us next month. It will appear in usual course. You did not, this is in February. You did not take any steps even after, for the first time you are mentioning today. Did you mention before this court? After the determination changed, when did you mention? Before this court? When did you mention? I permitted, I allowed that mentioning. The one that is in February, একটা আছে জুনেরটা, February advance করে দেখি ফাইল গুলো একটা দেবো। No, come next month. I'll mention next month. Yes, any other mentioning?
May I mention the matter that the application for restoration has been filed within the time limit, praying for the inclusion in the list.
Restoration. When was it dismissed?
Dismiss for default has been passed by Honorable Justice Nizamuddin on November 24, 2023.
By?
Honorable Justice Nizamuddin.
দিয়ে দিন list application. Notice? No, do not mention contempt applications today. Yes, call the list.
Supplementary list, item number 1.
Your Lordship. Your Lordship.
Hello, supplementary.
Yes, where is the report?
Yes. Work has been done, Lordship. Notice is
Where
issued.
is the affidavit, Mr. Shah?
Lordship, it's a original report.
There is a direction to file it by way of an affidavit, Mr. Shah.
It's been signed on 26th of June.
Kindly see the order, 24th of June,
I can
2024.
file it by way, but it has been done, effected. It has been, they have been called to make.
There is a
payment,
direction, has to be complied with.
but that could not be within this time. They have complied with the report.
Affirm an affidavit, come back tomorrow.
Your Lordship.
They have
Your
been
Lordship.
appear before the authority on 28th and make
So
payment within 7
affirm it
days.
by way of an affidavit and come back. There is a direction by the court.
I'll get.
He did not comply with the direction passed by the court.
Yes,
Please understand that is the reason why he has been directed to file a report in the form of an affidavit. This is no ordinary affidavit, sir. No ordinary report, sir. Yes. Call the next one. Yes, you are appearing for whom?
Item number 2.
Your Lordship, I am praying for the respondent number 5, Your Lordship.
Very well.
On the last occasion, the matter was
Item 2.
I'm for the petitioner.
Tomorrow.
Lordship, Monday.
Very well. Tuesday. ওটা Tuesday করে। তুমি মেনশন Tuesday করে দিন ওটাকে। ওই যেটা ছিল এটা তুমি মেনশনে ছিল তো। আগেরটা কিসে ছিল?
তুমি মেনশন।
Tuesday করে দিন তুমি মেনশনে। হ্যাঁ, ঠিক আছে, দিন।
তার আগে তো দেখি অন্য একেবারে মামলা করে বলে হ্যাঁ অন্য জানা তো Lordship, I am for the petitioner.
What is the interim order?
Not to take any coercive steps. This is the initial interim order that has been
What
passed.
connection it was passed? In what connection the interim order was passed?
In terms of an adjudication order, we challenge an adjudication order on the ground of violation of principles of natural justice because no effective hearing was given and cross-examination also was not given. And thereafter, the show cause was issued by the Directorate of Revenue Intelligence. So the point of jurisdiction is also
No, adjudication order or under
Adjudication order.
148 D?
adjudication order.
Adjudication order.
Yes, Your Lordship.
Cross-examination, you will cross-examine whom?
The transporter whose statement has been relied upon before the in issuance of the show cause notice.
Where is that? Which page is the order?
The adjudication order, your lordship.
Under the Customs Act.
Yes, your lordship.
Very well. Ashok.
15.
Again, I heard the learned advocates appearing for the respective parties. The interim order which is valid and subsisting till the end of June or until further orders
Lordship, it is starting at page 244 of the writ petition, your lordship.
are valid and subsisting. Valid and subsisting are উপরে করে দাও। The petitioners pray for extension of interim order. To stop the heard the learned advocates appealing for the respective parties. Therefore, next paragraph. The subsisting interim order, which is valid till the end of June 2024, is further extended till the end of November 2024 until further orders, whichever is earlier. List this matter.
Yeah.
The list of September 2024 under the heading hearing.
Lordship,
Matter is in the list. The matter is in the list. It will appear in September 2024. Interim order till the end of November 2024.
Up to 8th of November.
grateful, your lordship.
Item 3.
Item number 3.
For the respondent.
Well, I am for the
What
petitioner.
is the challenge, Mr. Sharma?
My lord, the challenge here, my lord, is the resolution plan was approved in 2018, which was confirmed by the Honorable Supreme Court. Now, post resolution plan, the Income Tax Department have been issuing assessment orders coming to a demand for the period which is covered under the resolution plan and becomes void in terms of the plan and the subsequent orders which have been passed by the Honorable Supreme Court in Ghanshyam Mitra and Ruchi Soya. And recently, my lord, same issue came up before the Honorable Appellate Court of this Honorable Court, my lord, where, my lord, the old appeal which was filed was, I had shown those two orders and the appeal was allowed and the impugn notices and orders were, that order, my lord, today I don't have in my hand. It was passed 3-4 months back. So I was, today, my lord, this has come up for extension of the
contention. What is
Lordship.
the contention? That once a resolution plan is approved, then what happens? The entire liability is,
My lord, they had
is in thin air.
no, my lord, the Income Tax Authority as
want to
as
understand.
an operational creditor, they had participated in they had lodged their claim with the resolution professional. And once their claim has been quantified or crystallized to say rupees,
Assuming they did not,
assuming assuming they did not, then
it evaporates into thin air.
no, then they could have, then if their claim is live, they could have taken action against me if it is not covered in the plan. And if it is covered in the plan, if it is covered, admitted position, they are covered under the plan and the plan has given them whatever they were entitled to. Now they are not considering the plan.
If it is not in the plan, for instance,
Lordship.
then whatever prior liability is there, it vanishes. No, it does not.
But if it is mentioned in the plan, it will
vanish.
It is extinct. If it is not mentioned, then they can take steps in accordance with law, provided their claim is live, limitation, and various other issues. But here they had participated, they lodged their claim with the RP, which is the resolution professional, and irrespective of the plan being approved, they have been issuing repeated assessment orders under section under section
Can you
140.
give me those orders passed by the division bench to my officer?
Pardon?
The orders which you
Yes,
said that
yes.
the division bench has passed.
Yes.
Can you hand over to my officer?
Yes, during the half an hour number, we will give them.
The petitioners pray for extension of interim order, full stop. Heard the learned advocates appearing for the respective parties, full stop. The subsisting interim order, which is valid till the end of June 2024, is extended till the end of November 2024 or until further orders, whichever is earlier. List this matter in the monthly list of September 2024.
Or lordship can keep any early date, any date.
Then I'll
Which is
say in November.
no, which is
It is not in the list.
No, it is presently not in the list.
Then-
It was directed to appear, but at that time your lordship was not the regular bench when it appeared on the last day. Now your
The
lordship is the
regular- I
regular.
saw it. That's why I'm saying.
Says
Directly
whatever date
appear,
is
you don't
convenient.
want that, Mr. Sharma.
Whichever date is convenient, because this will
No,
not
I-
take much time.
Hand over that, I'll consider. it.
Because we shall do that in half an hour. Interim order is a copy.
No, interim order.
Lordship extending interim order till no.
End of November.
No.
You want it earlier?
No. I want
We want finally.
the hearing to be earlier. Grateful.
Item number 4.
তোমার judgment গুলো দেখাতে থাক। আমার তোমার দেখো, জানা না। But I've annexed the first interim order in between.
Challenges?
Well, the challenge here is under the provisions of the Black Money Act, we have challenged the transfer of concurrent jurisdiction from Calcutta to New Delhi. The jurisdictional challenge that the officer concerned in Delhi could not have passed the order for the assessee in Calcutta. And my lord, my learned friend is here, my lord. This writ petition is ripe for hearing. The
In fact,
petitioners had concluded the
In
hearing.
fact, my lord, hearing had my lord progressed to a
Mr. Rai, what happens is in the process, everything is stayed. These matters take a decision and come back. What do you want to do?
Lord, hear it out, Lord, because affidavits are complete.
No, no,
Matter
no.
had been heard. My lord, the petitioner had concluded. I had
Choose your
begun.
good office. There may be some matters which you feel will not go your way. The
But this
matters
is
which
one
you
will-
consider that will not go your way, come up with a list.
Yes, that
Come
is
up
there.
because at the end of the day, the stay hurts the department also.
Yes, it is. It is.
So
But
it's
this is an interesting matter which your lordship should hear, my lord, because
very
it should be decided. My lord, it's an interesting
Same.
matter, my lord.
interim order যা ছিল petitioner single November and September in the list. No, it's there in the list.
No, now it's not there in the list.
Now it's not there in the list, my lord. It was there earlier. Now it's not in the list. You kindly include it in the hearing list.
September.
My lord, let it appear in the list earlier, my lord. The interim order is still November. My lord, if it is taken up earlier, my lord, the earlier the better.
No, I can't. I don't think I'll be in a position. I have my own assessments.
This matter, my lord, your lordship will enjoy hearing. My lord, it's really interesting, my lord. Black Money Act, Income Tax Act, my lord.
Can you also come up with a list? Consider, sit down with your clients. Then maybe stay in several matters. Consider, find out that
Yes,
some of the matters are not
Some of
really
the
worth
matters, yes.
continuing because at the end of the day, this is hurting the department very much. The revenue authorities are not in a position to proceed with the matter. So therefore,
yes, I appreciate this.
where it can be sent back, there are some matters which can be sent back. Unnecessarily stay will hurt and the petitioner will enjoy the entire session before the court when till such time it continues. Yes, call the next one.
Great.
Item number 5.
The petitioner, this is where, what is the order?
There was a search and seizure proceedings conducted at the place of business of the petitioner, pursuant to which a demand order was raised. The petitioner challenged the demand order in the departmental appeal proceedings, and the appellate authority confirmed the order of the adjudicating officer. And under section 112 subsection 8, we paid the 20% of the disputed tax in amount, and the stay was granted.
It has to be
till
heard
the-
finally, my lord. It has to be
Yes.
heard finally. Appellate order, my lord, has to be heard.
The petitioner prays for extension of interim order. First of having heard the learned advocates appearing for the parties and considering the fact that the
First
interim
order.
order is valid till
So ये affidavit direction.
28 June 2024. The same is valid and subsisting till 28 June 2024. The same is extended till the end of November 2024 or until further orders, whichever is earlier. List this matter. This is there in the list.
No, your lordship.
Yes, list for final hearing. Oh, list this matter in the monthly list of September.
Your lordship, the affidavit in reply is complete. May I place it on record?
Affidavit in reply filed in court today is taken on record.
Along with affidavit of service.
What affidavit of service? Affidavit of service I will not take today. After a matter has been heard, you want to put in an affidavit of service.
Item number 6.
As for the respondent,
Lordship, I am appearing for the petitioners. I'm humbly praying for the extension of the stay granted in the interim order dated 20th February. The stay was granted on the service of the assessment order, Your Lordship.
Assessment order stayed
So service of the assessment order.
on the service of the assessment order.
Yes, Your Lordship.
On what ground?
Your Lordship, we are challenging that the reassessment notice received on 1st April 2021 for assessment
Not
year.
by limitation.
this
Yes,
is for
Your
the assessment year 13-14. Now already Justice Nizamuddin, he has taken a view in respect of this 13-14, 14-15, my lord. So it will abide by that because it has not been tested yet. So it still holds the field. So this is for the 13-14, my lord. Now they have challenged the order passed under section 148 AD, my lord. That is the challenge before your lordship.
And there is an interim order directing you not
Interim
to.
order because at that relevant pointer, that is still continuing. That order which was there and the pleadings are all complete. I believe where you have filed your reply, no?
Yeah.
Pleadings are complete.
Complete. Very well. Interim order extended till the end of November. And September it will appear in the list.
September.
Much obliged, Your Lordship.
Next order.
Item number 7.
This is also for the extension of the interim order, my
What
lord.
is the interim order?
Affidavit
Staying-
opposition has been filed.
Staying the operation of section 148 notice, my lord, on the
What
ground
ground?
of time bar.
When
This
was it?
is
In respect of which assessment year?
17-18.
17-18. 3 years. They have issued the
But the pleadings are not
They have-
complete. I have filed my affidavit in opposition. They have not filed their reply.
No.
You have filed your reply.
Very well. The petitioner prays for extension of interim order. Stop having heard the learned advocates appearing for the respective parties.
What is it? এক্ষুনি তো।
No, should be having heard the learned advocates appearing for the respective parties, full stop. Next, the subsisting interim order, which is valid till the end of June 2024, is further extended till the end of November 2024. List this matter in the monthly list of September 2024 under the heading hearing. The
Yeah, I filed my
affidavit in
reply.
filed on behalf of the petitioner is taken on record. Affidavit in reply filed on behalf of the petitioner in court today is taken on record.
And copy be served.
No copy has been served. I will not take it up.
Copy has already been served, my lord. Well,
Actually, in
The-
course of today, they will file it. Let it be kept on record.
I have served, my lord. I have served. আমি দিয়ে দেবো, দিদি দিয়ে দেবো।
সব affidavit file হবে। হ্যাঁ, উচিত দেওয়া affidavit hearing. Tax matter. সব hearing.
Item number 8.
Your Lordship, this is for extension of interim orders.
I understand that, but what
Same issue, sir.
same issue?
Yes, Your Lordship.
Monthly list of September. Listed, end of November.
Lordship, affidavit in reply.
Hey, affidavit in reply filed in court today is taken on record.
Item number 9. I'm for the petition.
For the respondent. What is the
This-
challenge?
Section 148 notice on the ground of time bar.
On the ground of?
Time bar, my lord. 3 years, my lord.
Very well. End of November, I'm extending it. List in September.
Item number 10.
Seek my lords kindly. I am appearing for the petitioner.
What is the challenge?
Mine 148, second round of litigation. The first one was directed to the officer to consider afresh on the ground of a document of a bank. That was order was passed and again it is challenged.
And then what happened? They considered it.
What has happened?
Rejected the claim of the officer.
So the interim, why was the interim order passed? On what ground?
My lords, if I may humbly submit, what has happened in the second round of litigation is that I have been heard by one officer
And the order
Has been passed
admittedly
by
another officer, my lord. That is exactly what was held in the interim order, my lord. That I have a
Sir,
prima facie case, my lord.
Just a minute. Sir, consider this matter and come back. These matters, some of these are pending for some time now. Now, use your good office, whether the department will continue to litigate on this point. Otherwise, it can be sent back and completed. The matter will proceed because they are enjoying the benefit of the interim. And no hearing is taking place. So, use your good office, come back. I'll pass an order of the court.
Can I just take the instance?
Yes, yes.
If
Sir,
I may
wait,
hand over the-
sir.
Indeed, my lord.
Learned-
My friend said that in the adjudication opposition, detailed explanation has been given
Very well.
as to why this was done by the other officer.
Very well.
The
No,
reply is
now,
also
if
ready.
he has vacated the office, maybe then situation may be different.
If the officer is of the same rank, so somebody is hearing and somebody is passing the order. The question of overruling the doctrine of bias comes also into play also. There somebody is passing the order, somebody is hearing. So there is no allegation of malafide in the course of hearing of the proceeding.
Very well.
Paragraph 10 we have stated. If you lost it, kindly fix it at September.
But
Reply is-
since they are enjoying the interim order. Anyway, interim order till November and end of September. It will be listed, sir.
Indeed,
On
indeed,
this occasion, I'll take up
indeed,
this matter.
indeed. I am extremely grateful to my lord. Reply
Where
is
the
ready,
reply?
my
Where
lord.
is your reply?
My lord, reply
Where
is
is
ready.
your reply?
Reply copy now. It is ready, my lord. It will be affirmed and filed, my lord. The reply
You
is
have not
ready.
yet filed your reply.
The reply is ready, my lord. The reply is ready. The reply is ready, my lord.
It is to be affirmed.
It is to be affirmed and filed.
Then not be taken up. Very well. I'll just proceed on the basis of the pleadings. I'll not allow you.
Hmm.
Very well.
Reply affirm होइसे की? Affirm तो बोलो ना. My lord, my lord, the reply has been affirmed. It is only to be filed.
Serve a copy on the other side. Affidavit in reply filed in court today is taken. It has been affirmed. Yeah, why are you keeping it in your pocket again?
Affirmed.
Yes. Affidavit in reply filed in court today is taken on record. Serve a copy on the other side immediately.
Indeed.
Now.
We will have
Very
it served
well.
by
In
the end
course
of the.
of that. In
Yes,
course
yes, my
of
lord. Indeed, my lord. I am extremely grateful to my lord.
Yes. Call the next, sir.
Extremely.
Item number 11.
This is also for the extension, your lord.
Down.
Same, 148 AD, my lord. But here the
Limitation.
assessment year is 1617. But here the pleadings are not complete yet.
If they choose not to.
No, because they.
My learned friend did not file in opposition.
Because in
So there
spite
is a-
of repeated reminders given to the assessing officer, they have not turned up with the instructions, so I couldn't file it. So anyway, they have also contacted the concerned assessing officer because of the change of the assessing officer. This happens, so that went out of their mind.
The petitioner prays for extension of interim order, full stop. Heard the learned advocates appearing for the respective parties, full stop. Next paragraph. The subsisting interim order, which is valid till the end of June 2024, is further extended till the end of November 2024 or until further orders, whichever is earlier, full stop. On the prayer of the learned advocate representing the respondents, time to file affidavit in opposition is extended by a period of
3 weeks, my lord.
3 weeks from date. Reply, if any, there to be filed
2 weeks, my lord.
2 weeks thereafter. List this matter in the monthly list of October 2024. আর এটাকে না ডিসেম্বর নভেম্বরের বদলে ডিসেম্বর 2024.
Date.
Reply good.
Item number 12.
May it please your lordship, my lord. The issue involved is, my lord, whether in respect of self-same cause of action, two CGST authority can be, my lord, initiate action or not. Now, my lord,
Two
by
CGST authorities.
Yes.
Two CGST or one WBGST, one CGST.
one Calcutta and one of Assam, Guwahati. Now, my lord, the only by the interim order, the,
Calcutta is by CGST.
and Guwahati also CGST. Well,
Whether the
So,
principles of 6(2)(b) would apply.
yes, that is the issue involved here. Now, my lord, by the interim order, the direction was passed on the Guwahati authority to stay off their hand. Now, my lord, interim order is expiring. I am seeking extension of that.
Yes, the petitioner
And
prays for
one
extension.
indulgence I am seeking, my lord, the
Yes.
tax consultant of the petitioner died, so we could not file the reply. We need another extension, my lord, if, my lord.
So many times extended, my
My lord,
to file the reply.
if, my lord. That's the last opportunity.
No. You can come up on before the returnable date, I'll take up. Third petitioner prays for extension of the interim order. Third learned advocates appearing for the respective parties. First up, the interim order which is valid till the end of June 2024 is extended till the end of November 2024 on to further orders whichever is earlier. So first up, the petitioner shall be at liberty to file. List this matter in the monthly list of September 2024. First up, the petitioner shall be at liberty to file its affidavit in reply on or before the returnable date.
September. Monthly September. Instead of August, my lord, September instead of August, my lord. Instead of September, my lord, kindly take it on August monthly list.
No, September. These matters, they are not in the list, sir. I am listing that.
I'm grateful. Much
Yes.
Item number 13.
Petitioner.
Well, I'm praying for extension of interim order. I'm praying for extension of interim order.
Yes, means.
We are challenging the 148 order, 148 AD order as well as 148 notice for the assessment year 15-16. That they have issued the notice after a period of 6 years. So we are challenging that it is barred by limitation. The order cannot be notice cannot be issued after 6 years. And the other 2 points also raised the information they have provided by they have relied upon. It is not the actual information. This is not not verified at all. The ITA so that is we are challenging that this information cannot be relied upon against the petitioner.
Simon,
My lord, one more. My lord.
Item 11.
Yes.
Time to file an affidavit.
The same my lord, item 11 also, my lord.
Time to file
affidavit in opposition, my lord.
No.
There was
No reply.
The petitioner prays for extension of interim order. Full stop. Heard the learned advocates appearing for the respective parties. Full stop. The interim order which is valid and subsisting till the end of June 2024 is extended till the end of December 2024. Full stop. On the prayer of the learned advocate as prayed for by the respondents, comma, time to file affidavit in opposition. Sir, you had previously a sought for time.
My lord, I had sought for. I did not get that proper instruction.
Today, once again, the learned advocate representing the respondents seeks prays for an extension of time to file affidavit in opposition. First of all, on consideration of such prayer, time to file affidavit in opposition as and by before last chance is extended till the end of by a period of 4 weeks from date. Reply, if any, that to be filed within 2 weeks thereafter.
Grateful.
I'm grateful. List this matter, monthly list of October.
Great. Item number 14.
Liberty to mention on upon expiry of the period for exchange of benefit.
Great.
ওইটাই 11 of them. যেটাতে affidavit হচ্ছে না সেগুলো সব
For the petitioner, in this case, what happened, we are challenging the order dated 16th April 2022 passed under section 148 AD on the ground that this period was 15-16. The assessment also made. We subsequently, as per the income declaration scheme 2016, we have already declared my income shown before the authority concerned and I allowed their final form I have received. So the dispute has been settled long back. Then they have issued the 148 notice on the same issue. There is the interpretation of section 188 of the Finance Act of 2016, my lord. Whether there is, if it is settled, whether they can reopen once again or not. But there is a judgment of 3 high courts held in favor of the assessee.
Very well.
Lord,
In this case also, my lord, affidavit is not ready, I'm praying for extension.
Extended,
Similar to 13 months.
December 2024.
Great.
But I have not directed to appear. Liberty to mention upon expiry.
My lord. Great.
Great.
Monthly list, item number 33.
On the same issue, I have one matter, item number 15 of the supplementary list. Can you allow me to argue after Mr. Ghosh? But at first, my lord.
There are many matters on the same issue.
Is my lord?
There are several matters on identical issue.
Item number 15 is mine.
You are there in this matter.
Item number 15.
This matter, 33.
No, Mr. Ghosh is there.
Yes, continue.
Can you allow me?
No, don't mention. Kindly.
But after Mr. Ghosh, on the same issue, I will just address the court, my lord. Can you allow me, my lord? This is, I am getting some opportunity to make some.
You will get a lot of opportunities.
Kindly, item number 15.
Yes.
After Mr. Ghosh, my lord.
This is the issue regarding my lord.
Other matters?
First thing is my lord,
Other issues.
before my learned friend start my lord, they are challenging the central departmental notification.
They are challenging the
Central notification. That is
Yes.
168A. 168, they are challenging. Now the question before your lordship, now I have received the copy yesterday. Now he has given me just now the bindings.
Yesterday.
So my lord, your lordship
Why did you not hand it over earlier, sir?
But I don't know my lord, who is appearing for the state government. I, my lord, handed over the copy. Hey, my lord, central government. I handed the copy, my lord, on Monday to the, my lord, the state government advocates, my lord. Because, my lord, on the last.
The effect.
Yes, my lord.
You know the effect. It goes to the
My lord, in other
list of August.
my lord, my lord. My lord, in the other matters, my lord, on the same issue, your lordship has an order for the, my lord, direction
Asking for time, Mr. Maiti. Simple.
I have to file the opposition, my lord.
Oh, that is different, sir.
He is, my lord,
Because, my lord, yes,
If
today
you want to
also I am-
consider and come back, I can give you time. But if you want to file opposition, they'll have to consider his case for interim order.
No, they are enjoying interim order.
And in other matters, I am enjoying interim order.
In this matter.
No, my lord, may I only say submit one sentence. My
My
lord,
lord, what state has to say? This is the, my lord, the
my lord, state
notification of the central
notification
government. I don't know, my lord, why state has been, my lord,
obviously,
booking.
we are affected, my lord. If my lord.
How are you affected? Yes.
My lord, obviously, my lord, if I am not able to, I will also not get my share of the tax. Obviously, I am affected. But then why did my learned friend make me a party? But I one thing, my lord, I had all.
You're not a party.
Yes, I am a party. That's why they have made me a party. If I was not a proper or necessary party, why did they make me a party? My lord, what I
What
was
is the order?
my lord,
Previous order in
Well,
other matters.
my lord, may I just say one sentence thereafter pass it? My lord,
I'm not passing an order. I'm
I
asking.
had, my lord, kindly, my lord, from yesterday, I am beseeching my lord for 1 minute. My lord,
Yes,
kindly.
yes.
My lord, I have shown the Allahabad High Court judgment. Possibly, my lord, was handed over to my lord. My lord, I have today equipped with a Supreme Court judgment. Just one line of the judgment.
One line will not do.
No, my lord, I tell you what was the issue.
Yes.
The court,
I have not
the
started.
court
Then I have to start.
अरे बोलते ना must have requisite.
You want to argue on merits?
No, not on merits. What I am saying.
No, on maintainability.
No, nothing.
On what?
An order passed on a writ petition questioning the constitutionality of a parliamentary act, whether interim or final, keeping in view of the provisions contained in clause 2 of Article 226 of the Constitution, will have effect throughout the territory of India, subject to the course to the applicability of the act. Well, this is a.
I'm not saying the notification. Have I said the notification?
No. Today, the notification has been held to be intervened.
First, these matters, state was a party. State did not,
law is always valid unless declared ultra vires, Mr. Chakraborty.
That is what I'm saying. Two courts, there are 3 courts have held it to be intra-virus. At this point of
I have not declared it as ultra vires A. B. I have not stayed the act, the notification. Everything is there, sir. Right?
And my lord, they ought to have preferred an appeal to this or this kind of orders, my lord, passed by your lordships and my lord, the Justice Nizamuddin also, my lord.
No, that is an interim measure.
This is an interim measure, my lord. For the my lord, the balance of convenience, these are the my lord interim measures, my lord.
Liberty to proceed the so-called notice, not to pass the final order. That is your lordship's order.
Yes, how are you affected? I do not know, Mr. Chakraborty. How are you
in
affected
this
by
matter,
this?
this order was not passed. My learned friend accepted. In this matter, this order was not passed. On the first day, if my lord, the question of balance of convenience and inconvenience comes, in the first day, my lord, this order was not
No, no, no,
passed.
this is not the order. There is another order.
This matter, this order has not been passed. I'm
Mr.
saying
Ghosh, there is another order.
But this
Where I
this-
permitted you to participate.
Yes, my lord.
Where is that order?
Where, my lord, my lord, that is, my lord, where, my lord, your lordship, my lord, where the, my lord, show cause has been challenged. This is the order has been challenged. So, my lord,
What have you challenged here?
order. Order has been already been passed.
Final
Order
order is-
passed. Then, my lord, your lordship, my lord, interfered into the order and said, my lord, that no coercive measure has to take unless and until, my lord, the matter finally decided. And kindly take, my lord. Kindly take, my lord, page 4 of the, my lord, your lordship's order.
But let me see your challenge.
No, this is an order, my lord.
What is
My
your
challenge is, my lord, not only in the, my lord, way of notification, there is one point, and another point is, my lord, the violation of natural justice. That will, my lord, I will place, my lord, before.
Very well, then you served. You have not served on the Attorney General.
But I have sent the, to the, my lord.
Where have you sent?
Yes, I have sent, my lord. I have the evidence service, my lord.
Show me.
Yes, my lord.
They have received it.
No, still not.
Then come back. Then come back.
Then, my lord. My lord,
Monthly list, come back.
May I? My lord, today, my lord, central government advocates and my lord, state government advocates appeared before your lordship, my lord. My lord,
I am for
but
the
I have
government,
already.
I am not for the Union of India.
Union of India party.
Mr. Ghosh, if you face any problem, mention it. I'll take it up.
Okay, my lord. My lord,
But let the service be complete.
yes, sir. And kindly record, my lord, one and
Yes.
one order, my lord.
According to Mr. Ghosh, since service.
Yes,
No, according to Mr.
My lord,
Ghosh,
Union of India is required to be made a
According
partner. He has not made the Union of India. as a
My
party.
lord, the notification has been, my lord, issued by CBIC and my lord, GST Council. Both of them, my lord, I made
No,
both
no,
of them
no.
party, my lord.
Union of India has to be made a party.
Yes, my lord, kindly grant me leave.
On
I
the
will.
prayer of Mr. Ghosh, learned advocate representing the petitioner, Union of India, represented by
Nobody here has not made party.
Represented by, my lord, the secretary, my Ministry of Finance,
Department of Revenue, North Block, New Delhi.
North Block, New Delhi, 1110001.
give me the address. Give
My
the
lord, I will write it down, my lord.
On the prayer of Mr. Ghosh, learned advocate representing the petitioner, and upon considering the nature of challenge, liberty is granted to the petitioner's advocate and record to add with such and such as a party respondent to the present petition. First of the petitioner is directed to complete service, not to effect service. No, Mr. Maiti, you accept service?
I am for the CGST authority.
Yeah, you
Unless
can. The petitioner is directed to complete service on the added respondent. First up, the Mr. Ghosh, learned advocate representing the petitioner, however, submits that since the matter pertains to a challenge, since the writ petition seeks to challenge the notification dated 31st March 2023 and 28 December 2023 as having been issued in contravention of the provisions of Section 73 of the CGST stroke WGST Act 2017. Come on. He had where is your affidavit of service to that?
May I take my lord's leave, my lord?
To whom have you sent it? He has already forwarded the copy of the aforesaid application to the learned Attorney General of India. As also Attorney General of India, he submits that service on the learned Attorney General, service on the office of the learned Attorney General of India is not complete. First up, Having regard to the aforesaid, let this matter stand adjourned and appear under the same heading in the monthly list of July 2020.
I'm grateful, Your Lordship.
Here only, same matter, combined. Can
My
you allow me?
I have another same matter, my lord, let's just call in.
No, 36.
But 36, my lord, is same matter. Same order can be, my lord, passed, my lord.
I want you there.
Sir, mentioning I cannot allow, sir.
Same matter.
No, I cannot allow. Then the floodgate will open. If I accommodate you, Mr. Rai, in this fashion, floodgate will open. Mr. Rai, try and appreciate. It is a different matter in a different list. I have to apply my combined list. So wait for your turn. Yeah, that is done in this. 33, my lord, your lordship passed. Yes, yes. This is a virus challenge, my lord. I need to get the vaccination. Well, synopsis says VIRUS. Why don't we dismiss it? Let everything come back. We will consider. No, but the synopsis talks about a virus. Yes, I guess. So you should get it.
This is it. I need to get it out of everything. They are saying virus.
Call the next.
Item number 35.
Your Lordship, I am the petitioner. Your Lordship, here also we have challenged the virus of the notification which have been issued exercising 168A. Lordship, we have served the union as well. With my affidavit of service.
I will serve the office of the Attorney General.
Your Lordship, the additional government advocate, Ministry of Law and Justice has been served.
Since the petitioner seeks to challenge the virus of Section 168A of the West Bengal GST/CGST Act 2017, the petitioner is directed to serve a copy of the writ petition on the office of the Attorney General of India, as also on the office of the Learned Advocate General for the state of West Bengal.
I am for the Union of India, madam.
You accept service on behalf of the Attorney General? Then I will not allow direct him to serve further. Yes. And to file an affidavit of service to that effect when the matter is taken up next. This is the matter in the monthly list of August 2024.
Item number 36.
Have you forwarded this?
Same.
এই আগেরটা না, এর আগে 33 এর এই অর্ডারটা 36 এ হবে। July, এটা July, ওটা পাঠিয়েছি, he has already sent it.
এটা নিন।
You have already sent it, Mr. Ghosh. ঠিক আছে।
36
No, affidavit of service ফেরত দিয়ে দিন। Is not come back. Service is not complete. I've recorded.
Others has been come back, not Attorney General's office.
So therefore, cannot be taken up. July.
দুটোই জুলাই।
ঠিক আছে। I'm grateful, Your Lordship.
6. 42. Item number 42.
Milord, I am praying in a short password, Milord. Original supplementary affidavit as per the leave of the Honorable Court on the last question. And then lying with my junior, he is coming, Milord. He will be coming, Milord, very soon, Milord. On the way, Milord.
Monthly list. July.
At 2 p.m., Milord.
July monthly list. Come back, Mr. Chair.
Already brief.
In July monthly list, Monday. Yes, call the list.
As your Lordship. Item number 49 and 51.
এই ফাইলটা দাও, শুনছিলাম এটা।
But I was addressing your Lordship.
Yes. You did not conclude.
I did not conclude. I was about to cite the Bombay High Court judgment. The iPad ta dao. But kindly give me 1 minute, my lord.
একটা রাখুন, একটা। Have you shared the judgments with Mr. Rai?
My lord, the judgments
Citation.
which we have cited,
Yes.
that we have shared, but which are yet to be cited, my lord, perhaps have not been shared with Mr. Rai, to be very candid and fair to him.
Then he might take a time, he might say that I'll come on another day. That's a difficulty.
Then, my lord, what do we do?
No, continue.
Continue, right?
Continue. We'll conclude today, Mr. Rai. You tell me, just tell me.
But I shall not see his judgments only, then Lord I will, because I have my.
Yeah, then I'll place it on another date in, I'll fix it. Because I have heard Mr. Mojumdar in this matter. Then again I'll hear you today, again I'll on another date.
Then, my lord, what we can do?
Yes.
For the convenience of, my lord, of the court, because time is precious now. My lord, we can share the judgments amongst
That is the
ourselves.
reason what I'm
So
saying
that,
is,
my lord, when I conclude he is ready and
on that date, and it'll easier for me also.
yes, my lord. But can we do it tomorrow?
Tomorrow, yes, I'm ready. No, tomorrow is the application date. I'll fix it in monthly list with a particular date.
But don't keep it in the month.
With a particular day.
I see. Monthly is particular date.
So, it has to go to the monthly list with taken up a particular date.
Oh, Monday to 40 hobe na.
Monday it is not possible.
Monday nothing will be possible, madam. Request করেছে। আমরা তো মানি না request।
I see.
But this is an internal.
No, forget. I'm not for here. I cannot hear that. I cannot hear that.
This is our
Yes.
internal.
Okay, very well. So I'll place it on to Wednesday
Wednesday,
or Wednesday week.
Let it be Thursday.
এই Thursday কেটে fix করা আছে?
You share all the judgments with
আচ্ছা, fix করা আছে।
in the meantime. And we also
ঠিক আছে। List this matter in the monthly list of July 2024. Under the same heading, with a specific direction that the matter shall be taken up for consideration, further consideration on 4th July.
so we do it on Thursday. But we in the meantime share the judgment.
You have any difficulty on 4th? I can shift it on another.
I was just discussing with.
Yes, find out.
To share the judgment. One will also share his judgment with us, and the matter can be heard finally on next Thursday.
So not next Thursday, it's after that, any day, it's Monday.
Monday week, my lord. Monday week. तो swearing in ना हो जाए.
No, Monday week may not be possible. I fixed it.
Tuesday week.
Wednesday week.
Wednesday week.
But
Wednesday week, my lord, I don't know. तो इखाना থাকবো না তো.
in the morning.
Thursday week.
Thursday week date দিও,
Monday week
date দিয়ে।
Monday week it is
আর monthly list এর তলাতেও যেন ডেট দেওয়া থাকে। monthly list এর তলায় যেন ডেটটা দেওয়া থাকে। Thursday week.
Oh, PIL Thursday.
Thursday week.
In the meantime, we will share the judgments.
Share the citations, whatever
Yes,
judgments you want to rely, whatever he wants to rely, so that it can be concluded.
We will give the copies to Mr. Rai. No problem.
কোন ডেট করছে?
Item number 52.
Yeah, I list this matter on action. Claim shall be taken up for further consideration on full.
स्टार्ट करते हैं ना सर, आपको चाहिए ना तो हमको ये सप्लीमेंट्री प्लेस करना है, चाहिए तो प्लेस करते हैं सप्लीमेंट्री. But for last occasion, your lordship directed to get the GST status, portal status by way of a supplementary affidavit and reserve the crystallite. So we attended the reserve based on their MC address and it has been served. Earlier we took their GSTN address, it was in the portal. Then on the last occasion when the arguments happened, your lordship directed that you take from MCA. So MCA portal, the affidavit of service to the respondent 4, it has been served, and our supplementary affidavit also it has been affirmed.
Why supplementary affidavit? Why?
Lordship, supplementary affidavit to bring on record the portal status, the printout of the portal status of the return filing status of the respondent 4.
Yes, but what have you enclosed in that supplementary affidavit?
Lordship, the printout of the portal and MCA portal also, the balance sheet from the MCA portal.
Have you served on them?
Lordship, yesterday, sir.
Have you taken instructions? Because I've directed to verify it.
Verify. They have served it yesterday only.
Rest you have argued already, Mr. Kanodia. The only issue now remains.
Lordship, couple of points, Lordship. It has to be addressed to your Lordships.
No, he has not verified it.
Lordship, they had to take instruction from the Karnataka, from the department.
Whoever they want to, let them take and come back.
Lordship, till that time, your Lordship, protect me, Lordship, because my period has become time barred, Lordship. I requested your Lordship that I will come back to your Lordships in a short time. I had filed it.
Ought to have served it. This order was passed on 19th of June.
Lordship, 19, Lordship. Then taking the GSTN status in MCA, what happens, Lordship? I cannot download myself. I have to create a first login ID password as a independent person. Then I have to pay the amount. Then I can download.
Yesterday
everything is online, Mr.
Lordship, online. But Lordship, we have to get all those things organized, Lordship. Had it been GST portal, it was easy. But the MCA portal and then Lordship service, affidavit of service to respondent 4. We had to. No, you cannot download freely.
You can download freely, but it is accessible.
Accessible, download. And first 2 days it was not working. I have screenshot of that also. MCA portal is down.
I would have
Yeah, recently. Hyderabad. Lordship, may I place the affidavit of service to respondent 4?
The only issue is that this finding at page 99.
Page
99. You argued this matter. I remember.
Lordship, to that extent, your Lordship had asked me to bring the portal screenshot, which I have attached, and retry the service. And now I retried the service at the MCA address. Lordship, I have attached the MCA portal screenshot, which shows the company is still active. And Lordship, our court has.
We have to ascertain this because I will have to.
Lordship, our court
I have to pass an order in your favor.
Lordship, division bench of our court in Suncraft has clearly laid down the guidelines.
I know that. I've seen that.
Lordships. The Lordship has seen that judgment, and based on that, your Lordships asked me to do this.
That's the reason why I've called upon you to.
Lordships.
Yes. Let them take instructions and come back.
Lordship,
I'll place it next month.
Lordship, 33-24 was the order. 34, 35, 36, it will expire. Till that, now, Lordship, give me.
When will it expire?
30th of June. Therefore, I requested your Lordships was placing it in July. I requested Lordships kindly fix in June. Then your Lordship fix it today. Lordship, protect me till that time.
Place it once again. No protection. It will be over.
Lordship, then this too.
No, I'll finish it off.
Lordships, I will place Lordships.
Can you keep it next week itself, your Lordship? Monthly list next week. In the meantime, I'll send the affidavit.
Your ordinary 1 month will expire.
Lordship, my 3 months will expire.
Then you have another month.
Lordship, that is discretionable. It is not, Lordship, Lordship, it is discretion. Lordship, what happens? I'll explain you. In the portal, my liability register, they have already created a liability. As soon as this 90 days expire, if there's any balance in my ledger, they will start recovering. Automatic, not the officer. The portal will deduct it. Kindly sees the order. They have written that line also. Lordship, kindly takes the order. They give us a time limit to pay this amount.
Where?
Lordship. Lordship, page 104. The landed officer fixes a date, 28th of June, you have to pay this amount. Because 90 days expire on that day. Page 104, Lordships. May I please, Lordship? As no payment made by RTP within 30 days of issuance of notice, RTP is liable to pay penalty at 10% from DRC7 is hereby issued under 73(9), read with Rule 142(5) for realization of total amount of this. The due date of payment is fixed on or before 28 June.
I'll send it back.
Lordships.
I think no use staying these matters. It does not help Mr. Sanda.
Staying, but in this case, absolutely
No,
supplier
he's
is not traceable here.
No, he's showing everything is alive on the portal.
The
Hey,
documents,
देखिए affidavit টা দাও তো আমাকে।
kindly go through the documents.
Because you see, Mr. Sandal, I stay this. What happens?
Actually, the revenue will also suffer loss.
This way or the other way, the revenue gets to decide it. Either the revenue accepts this or it does not accept it. Because this is a factual aspect. This court cannot go into this.
Absolutely, Your Lordship.
Hey, देखिए दाओ। अरे,
Lordship, page number 6 of the supplementary affidavit. Page number 6, the portal screenshot.
Asian Motors.
I am not in favor of staying these matters. Because once it is stayed, Mr. Chakraborty, the effect is it will continue forever.
Lordships.
In this case,
Only in those matters which there is no other option.
Lordship, I am ready to argue, Lordship. I have never sought for a stay.
first he has to ascertain whether he has been able to serve to the
No, yes, the service is complete. Everything is complete, Mr. Chakraborty.
Don't shout at my ears.
Mr. Chakraborty, everything is complete.
Then, my lord, kindly allow me 2 minutes of submission.
Yeah, I will permit you.
Lordship,
Because and then I'll take up the matter for hearing. Once I take up the matter for hearing, then no
because I
further
have
instructions.
received the
Now,
supplementary-
if you take what instructions will you take?
No, I have
The
received-
factual aspect.
No, I have received the supplementary yesterday. My learned friend had served me a supplementary affidavit yesterday.
He ought to have served you earlier, but I can consider it and then I stay it and keep it.
No, my lord, I'll start with section 155.
No, I will hear you. That is not a difficulty. If I'm hearing you, I'm hearing you.
My lord,
On
can you
merits
give
there.
me one day's time?
No, 1 day means stay. 30th it expires.
Let him make his argument.
Yes. You see, difficulty is that.
Lordship, page.
Show me your service.
Lordship, affidavit of service I have given, Lordship.
That is different. But first of all,
Page 6, Lordship. GST portal screenshot.
yes.
Lordship,
Screenshot was live.
Lordship, legal name, trade name, constitution, GST and status, cancelled suo moto, effective from 6/4/21. Cancelled suo moto, effective from 6/4/21, Lordship.
Where is cancel suo moto?
Page 6, Lordship. Below third line item, GST and UIN status.
Yes.
Page 6, Lordships. First search taxpayer, legal name, trade name, Crystolite.
Yes.
Then Lordship, effective date of registration.
Yes.
Then constitution of business. Then GST and UIN status.
Cancel
Suo moto, effective from 6.
signed by the department.
So, Lordship, suo moto can be both. Suo moto by the SSC, suo moto by the department also. It can be both. From this, it is not evident. But in the order, the learned officer has stated that department has cancelled. But from this screenshot, from what is available in the portal, it says cancel suo moto. But the date is important, Lordships. The date is 6/4/21. My period before your Lordships is 18/19. 2018-19, April 18 to March 19.
So their liability remains.
The liability remains. Now, Lordships. Next page, Lordships. Next page is the general details, principal place of business, jurisdiction. Now, page 8 is the return filing frequency. Page 8. Lordship, filing details. The portal shows, Lordship, last 10 returns file status. Not more than that. Lordship, GSTR 3B. Filing of GSTR 3B in middle in page 8. 2019-20 tax period June, date of filing 22/7/19, status filed. 19-20 June he has filed up to. My period is April 18 to March 19. That is already covered in the before in the table, because the portal, Lordship, can reflect up to 10 return filing status. Now, Lordship, next table, GSTR 1. GSTR 1 he has filed till 21-22 April 24/7/21. This is the portal screenshot, Lordship. Kindly see page number 10. The date is there, Lordship. Site last updated on 19/6/24 in page number 10 of the GST portal. Site last updated on 19/6/24. This is what the
Where page?
Page 10, Lordship.
Where I don't get.
Lordship, copyright 24/25 GSTN. Then site last updated on 19/6/24. This is the status available in the portal as on 19/6/24. Now, Lordship, next page is the MCA portal. The information about the company is available in MCA. Lordship, kindly sees, it says active compliance, active compliant. Page number.
That means it is filing returns.
Active. It is not.
So it is filing returns.
Filing returns. Filing returns means that the company is there. Without the company, without the DSC, and I have attached.
Can you see the next page?
Sir, you see, today, if it does not file returns, its registration can be cancelled.
But ROC gives the time limit to pay late fee and get it restored. Like in GST, Lordship, so many cases have come before your Lordship.
Many matters which are pending before the court once it is not filed, what happens?
Lordship, that's an MCA compliance. He has
that
filed.
does not necessarily mean that the company
is. Let me address.
Company may be active on Mr. Kanuria. The company may be active on paper, but actually.
So my period is 18-19. I have to satisfy your Lordship that 18-19 the company was there. The company has filed its balance sheet till 31/3/20.
And service on them?
Lordships, affidavit of service.
Item delivered.
Item delivered, Lordships.
Share it with Mr.
Affidavit of service.
Yes. No, only that.
Supplement.
Item delivered. Affidavit of the show, Mr. Chakraborty.
My learned friend sees it, I believe it.
Yes.
I do not have to.
No, go through that because you have to make submissions on that as well. Because in other matters, I have seen that you rely on that report and say that because from the report it appears that the company, no service could not be affected, that prima facie, it's non-existent. So whatever is applicable for someone else should have to also be applicable for them. Although I did not accept it. Day before yesterday, perhaps.
I did not take.
Mr. Manager was arguing the matter. Yes, come back to your matter now once again.
Page 13 is the balance sheet for 18-19.
So, okay. Come back to your matter just once again.
Lordships.
Just relevant pages you show me.
Lordship, the relevant order page, Lordship. The demand order starts at 82, but the discussion finding starts at page 93 onwards.
No, 86.
No, 82 is the form. DRC 07 form. Summary.
Yes.
Lordship, page 99 I will place. Start. 99.
99 you showed me. I've seen.
Lordship, 99 you have seen, Lordship. So that
99,
is
this is the only line you placed.
Lordship, 99 from GST portal it is found that Messrs. This was cancelled by the jurisdictional authority for non-filing of 3B and due date of cancellation was 4/4/21. Since then, Messrs. Crystolite did not file any revocation application. Therefore, it is presumed that Messrs. Crystolite has closed down his business. Then, in case of ITC found reversible, these are other points. Then let's see in the order discussion starts at page 100. Page 100, Lordship. Last paragraph. May I please? Last paragraph, page 100, Lordship. From the ongoing discussion, documents and hearing, it is evident that inward supply was taken directly in relation to business or furtherance of business. As the RTP fails to furnish copy of all tax invoices as mentioned in discussion and finding, therefore claim of ITC is in violation. The documents furnished were incorrect to prove that RTP has actually received the service from Messrs. Crystolite, Hyderabad, from his branch office, West Bengal. Therefore, the claim of ITC is in violation of 16(2)(b). Even assuming that RTP did receive.
Go by this finding, Mr. Kanuria. This particular finding.
Lordship,
the documents furnished were incorrect.
Which one? The documents furnished?
101.
Lordship, that is the. He says that you have given tax invoice copies, agreement copies, but that person is supplying service
No,
from
no,
Hyderabad.
No. From the ongoing discussions,
Lordship,
documents and personal hearing, it is evident that the inward supply was taken directly in relation to business for furtherance of business.
So he
Fair
says
enough?
yes, it is for business. He does not dispute this. The officer writes that it is not in dispute that the supply was for my
The
business.
RTP fails to furnish all copy of invoices as mentioned in the heading.
Lordship, 4 invoice
Then I
copies.
find.
4 invoice copies, he says, during the course of the personal hearing, out of maybe 50 invoices, 4 invoices copies could not be traced. So he has recorded only 4.
Show me.
Lordship, kindly takes page number 94. He records it in a table. Page 94, Lordships. From the list as annotated, furnished by RTP containing invoice-wise details of IGST, ITC from Messrs. This, fails to furnish the following tax invoices.
How do I get it out of how many invoices? 4 were not furnished.
Lordship, that was a record during the course of personal hearing. Whatever was the total ITC availed during the course of adjudication. But Lordship, I will say how. Lordship, may kindly see 94. The table is there. Page 94 table is there, Lordship. IGST amount 59,000 in the first invoice, 3,600 in the second invoice, 2,700 in the third invoice, 22,860 in the fourth invoice. If I total this, Lordship, it will be somewhere around 85,000. The demand is of 11 lakhs.
You're ready and willing to give a go by to this.
I will, because I don't, if I cannot give a tax invoice copy, that is a basic condition under section 16. That is fine, Lordship. Lordship.
So you cannot challenge this finding. This is a factual finding.
Lordship, because
unless you can demonstrate, Mr. Kanoria, this is perverse. How can you demonstrate this is perverse? That it is based on no evidence. No evidence.
Lordships. But Lordship, I had given him a statement.
I cannot say this is based on no evidence.
No, Lordship, it is based on evidence. Therefore, he is writing, I am not disputing this fact.
Then you cannot question it.
Lordship, these 4 invoices you are telling.
I understand. In judicial review, when the court assumes jurisdiction, the court has to go by the evidence led.
Lordships.
And if you can demonstrate that the officer concerned had acted illegally, irregularly, and there is perversity.
I will, because the show cause notice was issued alleging difference in 2A, 3B. The allegation in show cause was you have availed ITC of 100 rupees in 3B, but in your 2A it is 80 rupees. So 20 rupees you reverse. During the course of the personal hearing, the reply to the show cause, I produce my input register of 100 rupees. He verifies 100 rupees. He says, see, 20 rupees is not coming in 2A. I say, 2A is not a document for availing the credit. I avail credit under section 59 on self-assessment basis.
It was only under 2A, 3B.
Yes, Lordship. Yes, kindly take the show cause. That was my point, Lordship. Show cause starts at, Lordship, page 50. The summary is at page 50. Detailed show cause starts at page 52. Page 52, your Lordships. The table in page 52, Lordships. Point number 2, ITC availed in excess. 2194, 495 IGST, integrated tax.
Where?
Lordship, in page 52, table.
Yes.
Serial number 2. ITC availed in excess. 2194, 495 IGST head.
So discrepancies were pointed.
Lordship, now kindly takes the pre-show cause at page 31. Because what they do, Lordship, they issue a show cause based on pre-show cause.
No, pre-show cause, okay, very well.
In pre-show cause, they have given the details. In show cause, they write whatever was there in pre-show cause.
No, maybe, but still then come to the finding page 54. The figures entered in serial numbers 3 and 4 of each taken tax and reconciliation statement is accepted when the supplier has uploaded his outward supply details in GSTR 1. The same is auto-populated in GSTR 2A, and if the said supply was made under B2B category, the auto-population in GSTR 2A confirms the same to that extent that the tax on such outward supply has been paid to the government exchequer. By virtue of this, ITC populated in GSTR 2A is taken.
So the dispute is whatever is not coming in 2A, he says tax has not been paid, you pay. The dispute started from this. I went to the adjudication. I gave my registers. I say I take the credit on self-assessment.
No, the third point is also there.
Which one, lordships?
GSTR 3B not filed.
That's a separate dealer. That I have reversed. That is not in dispute. That has not been confirmed.
It is only with regard to this particular
2A,
point.
3B, yes, lordships. Lordship, I'll take you to the order. He has dropped all these points. But 2A, 3B does not drops. Show cause is issued on the basis of 2A, 3B. Kindly text my reply, what I written. My reply starts at page 58 onwards. I have given point-wise reply. Page 58 onwards, lordship, and my submission on merit starts at page 66 on 2A, 3B. Page 66, para number 5.1. Lordship, 5.1, submission on merits. As regards mismatch of ITC as per 2A and 3B, the notices state it has been alleged that it has availed and utilized excess ITC by 24 this under IGST. Lordship, page 66, para number 5, last.
Yes.
Submission on merits. Submission.
Yes.
The notice states, as regards the mismatch of ITC, lordship, the heading is there. This is that 24 lakhs. The notice state that it has been alleged that it has availed and utilized excess ITC by this amount under IGST head in 3B vis-a-vis ITC appearing in form 2A return. The notices state that a denial of ITC merely on ground that ITC availed in form 3B exceeds the reflection in 2A for the above mentioned taxpayer is not sustainable for the following reasons. First reason, I give credit note deducted in computation including reverse charge. This is on that whatever is coming in 2A and whatever is coming in 3B is net of credit note.
Very well, but still then you were aware of all these points.
And I replied. Lordship, department
so it is not your case that you were not aware of some particular point and a decision was rendered on another point.
No, Lordship. I, in fact, during adjudication...
So therefore, it is not necessary to go into that.
Lordships. Now, how does the officer deal with the Suncraft judgment?
Yes, only issue on Suncraft.
Lordship.
Only thing, my lord, to kindly also consider whether, my lord, he has come before my lord after the adjudicating authority's order. He has not preferred an appeal. Whether, my lord, this is an exception. Till now, my lord, I have not seen anything on law my learned friend has said. It's on all factual disputes. Whether on a factual disputes or when there is an alternative remedy, whether my lord would exercise its jurisdiction under Article 226 on. My lord, all
interject and submit or let him permit him to submit and thereafter you will submit. Yes.
Lordship, the Suncraft order, how he deals with lordships. He deals with that page 101. May I place lordships? In the third paragraph, lordship, in case of 101. My lordships is there. In case of Suncraft Energy, the Honorable High Court, the Honorable Court held that in case of non-payment of tax by the supplier, the revenue has to proceed against the supplier for recovery of tax. However, the Honorable Court carved out several contingencies where the above provision will not apply. The relevant portion is reproduced below. I read. The first respondent, without resorting to any action against the fourth respondent, who is the selling dealer, has ignored the tax invoice produced by the appellant as well as the bank statement to substantiate they have paid the price for the goods and service rendered as well as the...
Well, very well. Since you are challenging this, Mr. Kanoria,
I have not been given any investigation report of the supplier. I asked them categorically that, see, these are my invoice. I have given the entire bank statement showing my payment to the supplier.
The direction to how much to deposit? But how much to pay? 11 lakhs.
11 lakhs.
20% of 11 lakhs comes to?
20% comes to 2.2. 2.2.
You deposit that, I'll hear out your matter.
But see, first appeal deposit.
10%.
First appeal is 10%.
10% you deposit that, I'll hear out your matter.
See, but in this case, he has not given any finding
No, but-
for the
I'll
adjudication.
hear it here. I'll admit the petition, hear out the matter. Are you willing to deposit? Tell me.
Deposit. I will have to take instructions from the SSC.
Take instructions. Immediately ask your advocate and record to take instructions and come back. What I will do is, I will admit the petition and thereafter I'll decide this.
I bow down to
because the question of alternative remedy is also there. So
Let me place the Suncraft judgment then, Lordship.
Suncraft judgment will
It was against the OIO, Lordship, and it was against on this point only.
Take instructions whether you're ready and willing.
Lorships. I'll come at 2.
No, I'll conclude it here and now. Ask your advocate and record. It will be difficult for your advocate and record. You have to go and speak.
Lordship, the total demand is 19 lakhs. Out of this, 11 lakhs is this. 6.
No, difference of tax. What is it? Lordship? Demand for tax is how much?
Total demand of tax, Lordships?
19 lakhs. So 10%.
19.23.
So 10% of that, whatever.
She'll just ask. Till that time, Lordship, give me protection.
Yes, because your difficulty is that you insist for an interim order.
I have shown your Lordship 28th of June, he writes in his order. And Lordship, when I am doing a business, the question is, in my credit ledger and in my cash ledger, the money will be auto there. The portal will remove that money as soon as it is there in the cash or credit ledger.
Suncraft at page?
Lordship, Suncraft is at page number 131. After Suncraft, Lordship, there is another High Courts have followed. The agencies, Kerala High Court, that is at 123. After Suncraft CTE judgment at page 128, our division bench. That was passed in April this year. And Lordship, page 142, Shraddha Overseas is very relevant, I would say. That was a case where the division bench dealt as to the presumption of cancellation. May I place that once? Page 142. Lordship, this was Shraddha Overseas, decided on 16/12/22 by the division bench. Lordship, may kindly take page 144, para number 6 onwards. On going through the order passed by the appellate authority dated this, it is seen that it is an elaborate order in which the entire factual matrix has been brought on record by the authority. Interestingly, in page 5 of the order, under the heading observation of the chair, substantial portion of the transaction have been found by the appellate authority to have been done with valid documentation. However, a doubt had arisen in the mind of the appellate authority with regard to genuineness of the transaction going by the payload of the vehicle which was used for transporting the goods in question. After noting this fact, the appellate authority straightaway refers to the action taken by the authorities of Ulta Danga, wherein the 2 separate inquiries were conducted in business premises of Messrs. This, and the inquiry was conducted on 14 November and 17 November this. Admittedly, the transactions done by the appellant was in October 18. Thus, to conclude that the other end dealer is a non-existing dealer, there should be material to show that on the date when the appellant had transaction with him, there was no valid registration. If the cancellation of the registration of the other end dealer is by way of retrospective cancellation, then the question would be as to whether it would affect the transaction done by the appellant, more particularly when the appellant have been able to show that the payment for the transaction had been done through banking challans. Thus, we find that the appellate authority was solely guided by the action of the Ulta Danga authorities without examining the specific facts. Further, in the case of the appellant is that in the show cause notice, there was no such allegation that appellants, and though through several grounds were raised by the adjudicating authority, none of the grounds were considered. Thus, we find that the order passed by the authority to be a non-speaking in the sense that there is no independent finding rendered by the appellate authority qua the allegation against the appellant. Therefore, it is a fit case. That is, the observation is there that presuming that the other end dealer was non-existent at that time, exactly my case, Lordship. He writes that in 2021, the cancellation is happened. So he is presuming that the business was never done. How can it be possible, Lordships? And this is binding, Lordships. We have placed this also. Lordship, Kerala High Court in the agencies kindly takes that, Lordship, at page 123.
Not necessary. It's all right. You come back with where is your instruction?
She is gone, Lordship.
Yes.
Lordship, kindly give. Lordship keeps that too. I will take the instruction back. She's asking. For the client person, she will call Piyush. Piyush will call the client. Then it will, because client will not know her directly. That's the CFO has to be contacted. Lordship. I cannot contact the finance manager. He will not take that decision. The CFO of the company has to be contacted.
Otherwise, I'll issue conditional order.
Lordship.
I'll issue a conditional order.
Conditional order, Lordship.
Conditional order of stay.
Payment. Lordship, agreed.
The present writ application has been filed. That will take care of the grievances of Mr. Chakra.
Lordship, 10%, Lordship. It is an appealable order. I would have gone to appeal, but why I came before your Lordships?
I will decide it. Next week, I will decide it. You pay it. Unless you pay, I will not decide.
Lordship, 7 days time you give, I will.
Yes. Unless you pay, I will not decide.
No, I will pay, Lordship. When the instructions are there, we will pay.
The present writ application has been filed inter challenging. The order dated 30th March 2024. 30th March.
30th March.
Wait. Passed under section 73(9) of the said act.
Okay, Lordship, the government has come up with the amnesty also now.
Of the West Bengal GST as stroke CGST Act. This is both.
Both.
CGST Act 2017. The ITC availed by you was reversed.
Was sought to be reversed.
Was reversed.
No, Lordship, that is the show cause, no? That excess ITC.
No, by the order, it was reversed.
Lordship, the demand was confirmed for reversal. I have not reversed it. Therefore, I am before your Lordship. The demand was for ITC reversal was confirmed.
Whereby the respondents have purported to raise a demand on the petitioner on the ground of ITC being availed by the petitioner in violation of section 16 within bracket 2 within bracket A of the said act. Inasmuch as this psychotype, this management agency, this agency was a supplier.
Lord, supplier of service.
What is the nature of service?
Manpower and manpower agency service. For the hotel facility management, various type of staffs are required. In the MCA portal also, they have defined.
Inter alia on the ground that Messrs. Christolite Facility Management Service Private Limited, with whom the petitioner had signed an agreement had closed down its business. We financial year for the financial year 2017-18.
18-19.
2018-19. when the aforesaid application came up for consideration, this court, by an order dated 19th of June 2024, had permitted the petitioner to place copies of printouts obtained from the GST portal showing the status of return filed by Messrs. Christolite Facility Management Private Limited by way of a supplementary affidavit. Question. Pursuant to such leave, the petitioner has filed a supplementary affidavit in court today and has disclosed printouts from the portal of the GST authorities, which was which was last updated on 19 June 2024, wherefrom it would transpire that the GSTN status of the said Christolite Facility Management Private Limited was cancelled suo motu with effect from 6th of April 2021. As such, for the relevant period, 2021. The same also records that returns in GSTR 3B had been filed by the said
respondent for
Christolite, puro naam diye, Facility Management PVD Ltd for the tax period 1819. For the tax period
3B last file of June 2019.
March 1819 for the tax period March 1819 to September 1819.
Lordship, before that, the portal will not give screenshot, but the law says if I don't file previous month return, then next month I cannot file. That means the entire return for the financial year has been filed.
I see. So, for 1819. The aforesaid would prima facie demonstrate that Christolite had been complying with the provisions of the said act at least up to the year, up to the tax period 2018-2019. Stop. Having regard to the aforesaid, I am of the view that the present writ application, having regard to the aforesaid, Mr. Chakraborty, Mr. Kanodia, learned advocate, representing the petitioner, submits that the order passed, order under section 79(3) of the said act, 73(9) of the said act, dated 30th March 2024, is based on no evidence and is perverse. He prays for stay of operation of the said order. Mr. Chakraborty, learned advocate, representing the respondents on other hand, submits that the petitioner এই যে ওই চক্রবর্তীর ঠিক আগে ওখানে ওই মিস্টার কানোরিয়ার আগে, হ্যাঁ আগে ওই লাস্ট পার্টটার আগে, by placing a press release dated 4th May 2024, it is submitted that by placing a press release issued by
Lordship CBIC.
Where do I get it?
Lordship, it is actually in the Ministry of Finance portal. So from that it is downloaded like this. It is by Ministry of Finance, MOF.
Dated 4th May 2024, issued by the Ministry of Finance, it is submitted that it has been clarified that there shall be no automatic reversal of input tax credit from buyer on non-payment of tax by the seller, and in case of default of tax by the seller, the recovery shall be made from the seller. However, reversal of credit from buyer shall also be an option available with the revenue authorities to address exceptional situation like missing dealer, closure of business by supplier, or supplier not having adequate assets. So he submits that in the instant case, the respondents without ascertaining, in instant case it would be apparent that at the relevant point of time, he said Christ to strive, such and such, and had filed its returns, and the same cannot as such be considered as an exceptional situation for the respondents to proceed against the petition.
Lordship, also that the affidavit of the service was complete.
Perverse কথাটা. Mr. Chakraborty, learned advocate, representing the respondents, on the other hand, submits that the petitioner has an efficacious alternative remedy in the form of appeal. This honorable court, at this stage, without the petitioner exhausting its remedy, without the petitioner exhausting its alternative remedy, should not take up the petition.
Just one more submission, it might not, if it comments, 16(2)(c) has not been complied with. Kindly that. Because the language of 16(2)(c) subject to correction would kindly consider.
I will hear out next week, Mr. Chakraborty. I will hear out next week. I'm just putting him to terms so that 10% at least deposited.
For Hayat, it is nothing. For Hayat, it is nothing.
Hayat can say, I cannot comment.
Having heard the learned advocates appearing for the respective parties and having considered the materials and record, since I am of the view that the writ application should be heard, first of having regard to the prima facie case made out by the petitioner, there shall be a stay of the demand raised by the authorized officer, a proper officer.
Respondent number 1.
As is reflected in the order dated 30th of March 2024, subject to the petitioner depositing 20%.
Lordship, 10%, Lordship.
10%.
10% of dispute.
20%.
No,
There is no financial.
Of the demand.
Lordship, tax.
10% of the demand.
Demand of tax. Because in the demand order, interest penalty, everything will come. 10% of the disputed tax, which is at page 82.
10% of the disputed tax amount.
Lordship. Page 83, the disputed tax is?
Yes, disputed tax amount.
Lordship.
Thanks. With the GST authorities. Full stop. If such payment is made, such payment must be made within a period of 7 days from date. If such payment is made, the interim order passed herein shall continue till the end of June, till the end of July 2024, or until further orders, whichever is earlier. List this matter under the same heading in the monthly list of July 2024, and with July 24, the matter shall, however, be taken up for further consideration on 17th July 2024.
I'll just
17th July, my lord had fixed another matter at 2 p.m. Whatever.
It will be in the morning.
Oh. 17th is normally it's a holiday. Possibly we will be having a holiday.
23rd July 2024. If I cannot complete it, I'll reserve it and finish it off.
Yes, my lord, kindly decide.
Because these matters cannot continue, permitted to continue.
No, no, but once, my lord, one issue is, one matter is decided, but if you can follow other matters also, other matters passed accordingly. 23rd July, your lordship has. Good day for you. Yeah, good day. Grateful to you.
এরপরে যেটা আছে সেটা
Item number 56.
Service tax. What's happened in this case, my lord? As I repeat shortly, my lord. My client used to carry on the business of certain works contract with the Public Works Department, Government of West Bengal. She has done the work of 2012, 13, 13, 14. Everything was paid. Now, sadly, my lord, in 2020 November, a show cause notice was served on my client, alleging that you have not paid the service tax, and the entire amount has been summed up. So this entire amount you have received, flat rate on the entire amount that I have received, 1.60
Yes,
crores.
Mr. Maiti, what is your instruction?
But my instruction, they have not submitted the work order, neither the original copy of the bills. Nothing has been submitted before the authority to prove that they have worked for the governmental authority or local authority.
Send it back.
To submit the same. But this is an appealable order.
Entitled to, he is entitled to mega
He's
exemption.
entitled- Why he has not
He is
provided the
entitled to mega
documents?
exemption. Why will pay for Mr. Maiti?
My lord, I am not saying that he is not entitled. But
Have you seen the last order?
yes,
I have recorded. I usually after hearing them at a record.
Yes.
And this also helps all of us. So what your learned friend argued, what Mr. Ghosh argued on the last occasion,
yes,
was that by reasons of the mega exemption, he is entitled to
entitled.
anyway. Now you say that he has not submitted any documents. Maybe he has not submitted any documents. Now, if he has not submitted any documents, today there is a show cause only.
Yes. So no, adjudication order has been passed. Adjudication order has been passed.
Set aside the adjudication or send it back.
My lord,
Say,
suppose tomorrow, my lord, the company goes anywhere, where the government will go.
It's not a company, Lord.
My
She's
lord,
a lady.
at
Personal
least
lady,
direct them to deposit the
She has not migrated
deposit
to this
amount to the
Very
government authority, my lord, to prefer the appeal.
incorrect, sir.
They are liable to pay 7.5%. At least that should be given.
Absolutely incorrect
Not
submissions
appeal.
made.
No. We are not saying that
There is
appeal.
no
my
liability.
I have submitted.
According to him,
yes,
there is no liability because do you dispute the mega exemption notification?
I am not disputing, my lord. My authority concerned, kindly see the order. Kindly see the order.
I have submitted the work order, sir.
And Mr.
Well,
Ghosh, you had
kindly
made
come-
your submissions. I had recorded your submission. Have you seen the order? No.
Yes.
I have already recorded your
I've
submission.
got the order.
Yes.
Page 59, my lord. Last paragraph. The examination of the copy of works order reveals that memo number such and such dated 28 December is about work order on the subject drilling, laying and pipes for water supply work in the district of South 24 under Diamond Harbour Division during the year 2012 and 13. And the same memo number such and such is showing another work order for construction of Kagdip Port building in the district of South 21 under Diamond Harbour Division during 2012-13 under issued by the Superintendent Engineer South Circles PWD. As the assessee failed to submit original work orders for verifying the authenticity of the same, I find that it is not feasible to infer that the contractual price received during the relevant period refers to the above referred work orders. Further, memo number such and such in the subject construction, girls and boys hostels and group 0 staff on memo number such and such dated 15/12/2014 on the subject construction. It two number pumps for
Where is your final bill, Mr.
final bills.
Mr. Ghosh?
But the trouble is this, Lord. The
Your
work
final bill you have to produce.
No, but the bill copies are not given to us. But the payment certificate is given to us. That we have disclosed. The work orders we have received, we have disclosed to them.
And the payment certificate issued by the government?
Government, PWD. Because they have to submit the return, income tax return.
Why did you not file it?
Well, I have submitted to them.
Where is that? Payment certificates you have submitted? Show me that payment certificates you have submitted. And where is the payment certificate? In petition?
But
Have you disclosed
may I
that?
file a supplementary because those I'm told by junior that should not be annexed here. But the statements, your lordship, kindly come to page 42.
No, payment certificate, if you have not submitted, then nothing remains. Where is the payment certificate?
Lord?
To privacy hold in your favor. This is the law. Now, facts, law has to be applied in the facts of this case, Mr. Ghosh.
Absolutely correct.
So therefore, if you have to substantiate the same by factual basis. Where is your basis in the petition? Show me.
I have submitted the work orders.
Where is that? Work orders you have
There are
submitted?
work
No.
orders.
What about the payment you have received?
Payment I have submitted. On the basis of that, I have submitted the entire income tax return.
Where is your such payment certificate?
Payment cert that has not been annexed here in the report. But the statements have been annexed. If your lordship comes to page
No,
42,
you produce the payment certificates.
these are the
Statements will not do.
This is the payment certificate certified by the government.
Where?
Page 42. Your lordship will find at page 43, signed by the executive concerned. Page 43 at the bottom. You will hear them. I'm sorry, but it's not been correct. Oh, take it.
No, there is no stamp.
Yes, blood. On the bottom.
There is no stamp.
On the bottom.
Verified and found in order.
Page
This is a typed copy. No stamp.
Page 43. It's a continuation of page 42, 43. It's a continuation of 2 pages. At the bottom, you'll
no, 43, I can understand there is a stamp.
But these 2 are continuing. These are the total payments for the years. They wanted us, we have given it.
Let them verify the payment certificates. These certificates.
This should be considered.
Yeah, absolutely. Why not?
Why they not?
Why not?
It will be considered by the concerned authority.
Yes, you are not required to consider.
Yes.
I'll send it back. If he has not considered this, you see.
If he has filed this, I don't know whether he has.
Well, the difficulty is this.
You have filed this.
Yes, by the joint commissioner. The decision was made by the additional commissioner. That's the difficulty. And he did not serve me any notice. I had to talk with the client. She said, no, I have not received any notice from this additional.
Where is the decision taken by the
blood? I have annexed that document.
Additional commissioner passed the order. Matter was heard by
show cause by joint commissioner. He heard the matter.
Yes.
He heard the matter. He called upon.
And some other officer has passed.
Other officer has passed out. And that's the difficulty with that.
I'll send it back.
But your lordship, kindly see what has happened. Kindly see.
Let the PWD, they can easily verify for the PWD.
And then I'll admit and here.
Kindly come to page 58.
Let them call the PWD there in. PWD verify it.
Why PWD is going to come?
It is for you. Onus is on you.
I will call them.
Onus is on you.
I will call them there.
By documents only.
Yes. Let the PWD produce
No, there is no evidence. Taking of evidence.
Difficulty is that
if you are not
given to us, these are with the PWD.
You have to I have record that you disclose. I'll grant you liberty to disclose all original documents.
Very well, I'll call upon them.
I'll kindly see page 58 once again.
Yes.
Paragraph 50. Reply of the notice and record of personal hearing. Middle, my lord. The said notice did not submit any reply against the show cause notice in his defense till date. However, the notice has been given.
That itself is a false statement. I have the document.
That by which a personal hearing on such and such, but the notice failed to appear all 3 personal hearing on the scheduled dates. Further, it is pertinent to mention that the said notice was intimated of the personal hearing on all 3 occasions by Piscode as well as email ID number such and such, respectively. But the notice had not appeared in any of the 3 personal hearing provided. The notice by email number such and such requested to adjourn the personal hearing on such and such. He was suffering from viral fever and submitted some documents through authorized representative like 3 CD, 3 CB audit report, balance sheet, profit and loss account, and 26 AS for the financial year 2015-16. So what the documents he has submitted, that has been recorded.
How can he submit the documents if he has not appeared, Mr. Maiti?
Mail. Through mail. Through mail he has already
given. So he has responded? So he has responded?
He has responded by saying the documents. But what is the defense to deny?
He has, where is the mail that you received? Where is the mail that you received?
Mail is produced, my lord.
Where? Show me.
No, that today is not with me, the mail.
Matter is there. Where is your mail? Show me your mail.
Lordship, kindly come to page 51. That have
yes, that is the mail.
Page 51, that I have replied to the joint commissioner.
Yes.
Because this additional commissioner is not taking to anything. It's not a false statement this man is making.
Everything, entire defense has been spread out. You have not considered his defense. What are you saying? 51 is there. And you say that he has not responded. Mr. Maiti, your officers are not doing it properly.
Kindly see 51.
Yes, see 51. I am on 51.
The above service exempted from levying a service tax under mega exemption.
This was served on you.
Joint commissioner who really called upon me. She said, lady, she's coming from the remote village. Kagdeep. One has to
But it
consider
has
it.
been given to whom, my lord? I can't understand, my lord.
Joint
Not
Commissioner.
Stamp, no stamp, nothing is there, my lord. Page 51, kindly see.
And you acknowledge that he has sent a mail.
That is 19/5/2021, my lord.
This is 19/5/2021, 15, page 15.
Yes, 19/5/2021. It is has been given to the
Reply
Joint
to the
Commission of
letter dated
Securities.
20th of April.
23, this is 2021.
This is 15/9/2021.
Make
and
up your
image is
mind. Make up your
2023.
mind what you want. I can admit it, grant you liberty to file affidavit in opposition.
My lord, that may be. That may be.
And the authorities will go on suffering.
Authority will go.
Because
your
the
lordship-
truth
if
will
your
not come out.
lordship-
Because the truth will never come out. Because
No, my lord. I will produce before your lordship whatever the documents with us and what he has given to the department. That I can substantiate before your lordship by filing my affidavit.
when do you want it?
Within 2 weeks, we'll file my
No,
affidavit.
now it goes to now the in continuation of this order, I have to pass an interim order.
Yes, my lord. Your lordship can pass the order.
Difficulty is Mr. Maiti. This only creates the problem that once an interim order is passed, it will continue.
May continue, my lord. But we cannot say that, my lord, that he has submitted all these documents and we have not considered. That cannot be. That cannot be, my lord.
Where is your document? Where is your document? So this admittedly, this was show cause by one and hearing by another, final hearing by another.
Why, my lord? Kindly see that that has been also discussed. And page 58, my lord. Page 58, last paragraph.
Yes.
In exercise of the power conferred upon the Chief Commissioner in terms of Rule 3 of the Service Tax Rules, read with notification for liquidating the pendency of the adjudication of the service tax cases pertaining at different levels under his zone, the subject service tax SCN was assigned to the undersigned by order under such and such, dated 18/7/23, issued by the Additional Commissioner CCO as per order of the Chief Commissioner, dated 16/11/2020. Accordingly, this file has been received from the Kolkata South Commission and is taken up for adjudication. He has given
Did you appear before the Joint Commissioner, Mr. Ghosh?
Yes.
Where have you stated that? Which paragraph? Which paragraph of the petition have you stated that?
Kindly bear me for a moment. But I have stated in paragraph 14, I received first notice from the superintendent, then replied, then the Joint Commissioner, paragraph 16. Then we replied on paragraph 17.
Thereafter?
Then
Where did you
after state
personally
reply,
appear?
have hearing virtually accepted exemption, paragraph 18, page 8.
Where
Joint
paragraph,
virtually accepted
which paragraph?
exemption, but impugn order dated
No, paragraph, which paragraph?
18, page 8.
Please read it.
But that after the said reply, the said Joint Commissioner respondents have hearing, respondents held hearing and virtually accepted exemption. But impugn order dated 29th April 20.
Where have you said that hearing was given? That you have participated in the hearing? And where is your payment receipts?
But the receipts.
Certificates, where are certificates? There is no statement by you. So
Statement.
your case that you are trying to make out is not supported by statement.
We are
So you
only
submit, Mr. Ghosh, you
receipts are not given to
submitted.
us.
You submitted that hearing was given by a person, but the final order was passed by someone else. That is not supported by a statement made in the petition, sir.
But the Lordship, kindly bear me for a moment. But kindly come to page 12. Ground number 15.
Ground will not do. Statement has to be there.
But I think this will, if your Lordship kindly allow me to place this paragraph once more, that after the said reply, the said Joint Commission respondents held hearing.
Have hearing and
Have
virtually
hearing.
accepted.
Have hearing.
What is the meaning of this?
Have hearing means that must have
No.
accepted. Otherwise, hearing means ex parte hearing.
How do I know?
Petitioner did not write the
You
expert
did
here.
not clarify, can't make head and tail out of it.
And virtually
Have
accepted
hearing and virtually accepted exemption.
Then, but impugned order dated 29th purportedly rejecting the reply of a petitioner without considering the facts as stated by your petitioner, including legal issue and purport directive.
On the contrary, it is recorded that no hearing took place. Where is your challenge to this finding that this is incorrect?
But this really starts from paragraph 14 onwards, where the first I was called by 3rd of November 2020 by the superintendent of the respondents.
Where, which paragraph?
14, page 6.
Yes.
Called upon the petitioner to submit construction works executed by a petitioner under Public Works Department, Government of West Bengal, so and so.
This is prior to show cause.
Yes.
That is not necessary. Prior to your, what is your contention, Mr. Court?
Procedure that
You submitted very clearly that someone else heard the matter, someone else passed the order.
Yes,
so that I would examine that. Now, while examining this, I do not find that statement.
But may I tell you, Lordship, what the procedures are followed? Normally, the first notice is given by the superintendent, asking for certain documents, not anything else. But the documents were called upon after 7-8 years. That is expressly barred by limitation under the Act itself. Then you will also kindly come to paragraph 14. Paragraph 15. In compliance to sale letter, your petitioner furnished detailed statement along with declaration in the form.
Where have you taken the point of limitation?
Lord, that's the ground I have taken. In the ground,
no, where in the contemporaneous response, where is the ground of limitation taken by you?
Lord, the fact, the law is abundantly clear. If the law provides that within 18 months one has to raise it, after that it goes to absolutely cold storage. Then another clause has been added to that with a proviso that it could be extended to 5 years provided there is a fraud, provided there is a suppression. But there is no suppression because PWD has clarified it. We are not paying service tax because the service tax authorities have said.
Did you invoke the extended period? Where did you invoke the extended period?
Page 50.
Oh yes, 73(1).
Yes.
That is in the order.
But your lordship, that is in the show cause also.
No, show cause. Extended period has been invoked.
Invoked.
So once it is invoked, you have to challenge it.
Yes, we are challenging now.
Where in the response?
Challenging it, no? In the REIT application,
sorry, sir. In the REIT, I can't permit you to challenge it for the first time.
In the show cause reply that we have said so, that's at page 51. That is precisely that we are exempted. And 2000.
You did not take this point. What you took, I have recorded in the previous order.
Then, Lord, kindly come to this paragraph also. I further state that we are not authorized to make a bill, but all the bill are prepared by state government. State government are prepared and
actually the final bill is prepared by the state government. So copy of the final bill will be with you.
No, not with me. Because under the PWD
final bill you sign, it is presented. Yes.
Just 30 seconds.
Yes.
Not more than. I have appeared in so many arbitration matters.
Yes.
I've seen it. Not a single contractor prepares the bill. If a bill is submitted by the contractor, then the
department prepares it.
Because there is a PWD, under the PWD code itself, there is a form, prescribed form. For form 26 is for the final bill. PWD accounts form issued by the, or rather prescribed by the AG department, government of.
But you will get a certificate for that.
No, the bills are not given to us.
No, you will get a certificate of the payment given by the government.
Only that certificate which I have annexed.
That is the payment certificate.
That is the payment certificate given. This kind of payment.
Where is that?
That is page 44 most probably. 44, 43 or 42. Kindly bear with me for a moment, Lord. I have a page 42. Sorry, page 42, 43.
So this is the only document available.
Certificate on the basis of which we file our income tax return. Because the government has deducted our income tax. So everything is available. That's all.
Very well. This is 42 and 43. Ends 40 and ends at what is 44?
44.
No, what is 44?
44 is another one, another 10 works. Not 10 works, but payments are 10. 10 payments, maybe 2-3 works. Yes, 1, 2, 3.
No, 44 is not continuation.
Not continuous, it's separate.
Separate,
Separate.
unsigned, cannot be relied on.
It's signed by my client, Lord.
Your client may have signed it, not signed by the
Submitted to
government.
them.
On behalf of the government, there is no stamp of the executive engineer.
Normally, it's signed by the divisional accounts officer or executive engineer.
So it is
Here,
not
Lord,
there.
in page 43, both have signed it.
Correct. So page
And here
43
it
shall
is
be
not-
taken into consideration.
It has not been signed by them. But it may be
So
that.
this is
my
for the year
client is-
2015-16.
Yes. Payments are being made. Works are executed on 2012, 13 and up to 14. The payments are being made by the government in 2015, 16, up to 17 before GST. This is the way the government is making payment in almost all cases.
No, no, RA bill is there. RA bill is
Running out bills.
2015.
Yes.
So if a RA bill is 2015,
But
so
the-
naturally you're getting advances against payment.
Not advances, Lord. May I tell you, Lordship, Lord, the
Yes.
running account bills, normally, even we have seen, the work has been completed. The government doesn't have the money. What the government does,
The RA bill
pay
will
one
not
of
be
the RA
released.
bills to them for the purpose of.
No, that is
constructing the work.
unacceptable, Mr.
This is how your Lordship find the payments have been made. Payments have been made by same work 1, 2, 3 at page 44, your Lordship find. 1, 2,
You
3,
cannot
same work.
pass off what they are trying to hold. Is that you cannot pass off one work for another. You may be doing some other work also. Your exemption is only in respect of the work
PWD.
executed by the
I have
government.
not done so. I've said so. That I'm only doing PWD works.
The saying will not do there.
My
Supporting
income
documents
tax,
has to be.
my income tax details they have, which you have disclosed to them.
Income tax they do not rely.
And that is what the income tax return. On the
If
basis
they
of that, they
cannot
have
hold you
calculated.
responsible on the basis of income tax returns, you cannot also absolve yourself on the basis of income tax returns.
They also cannot calculate it.
They are not calculating it.
They have only total amount. They have taken it from the 26 AS. That's what they have done. And no
26 AS is
total amount that flat rate amount has been taken. Total amount 10 crores, pay it 14-15% and 1.60 they have come out.
Mr.
Not the
Mr.
30%.
Mighty 26 AS would demonstrate who is the who is the deductor.
In terms of 26 A's.
Correct.
Now your lordship will kindly
It
say.
will be very clear therefore.
So when they are filing, they are saying that we are exempted. We are not liable to pay. So in that 26 A's, what he has shown, what is his total income from service?
No, no, he is not required to show 26 A's.
Yes, no, no.
26 A's, the deductor will
That is the
deposit
income tax of
and that will be reflected in his statement.
statement. Yes.
In his statement in 26 A's, that will come up.
Yes. Kindly see page 46. Last paragraph, 2.1.
Where is your statement of 26 A's?
That has also
Here.
been noted.
But I'll tell you. One of them is with me, my lord.
Show me.
Not in the petition that has been because
Very well, show me.
and we made Xerox. Okay, so it is 26.
The name of the tax deductor will appear because the TAN number will appear there.
But if your lordship looks into that, I think this will clarify. और अच्छे आपने ठीक है तो already PWD. How's it PWD?
It is not limited to the government contractor. There are others also.
These are
Yes, Axis Bank is there.
Axis Bank.
Naturally. As
Axis
the
Bank is
fixed
not,
deposit.
I'm not executing the work.
Not
Bank
necessarily. So
is
therefore, you
deducting-
cannot get benefit of that.
No, But I'm not being able to clarify, Your Lordship, Lord, because this really tax is something different for me. Difficult job for me, Lord.
You see,
The
in this
taxes
form,
deposited in-
whosoever deducts tax,
Deposit in the bank. Shown in my accounts.
it is shown here.
Yeah.
Their name appears,
TDS.
their TAN number appears, and the transaction and the date appears. So you see the third page, assessment year 2017, 16, 17.
Would Your Lordship,
Here I'll find serial number 1 under the heading Executive Engineer, South 24
Yes.
Parganas. There are 2 entries. Only 2. Then Kagdi Block Health and Family Welfare Samiti.
Yes.
There are 5 entries.
Yes.
Then Office of the 4, serial number 4. Then Office of the Executive Engineer, Diamond Harbour. There are 19 entries.
Yes.
Thereafter, West Bengal, some corporation, there is 1 entry. Then comes Axis Bank. There is around.
But the Axis Bank is, Lordship, will find the different sections. Those are on interest chapter.
Correct.
So this will not apply to this service tax portion.
Correct.
So only a service that is being given by my client to the PWD, those are all executive engineers. So these are what my 1126 is not the thing. This will reveal everything there.
You disclose this document to them. On the basis of this document,
Have given it. If they are asked it, we'll again give it. And we'll call upon the
take a
PWD
decision on this. Rehear the matter. I think that will be better.
Yes,
Mr. Maiti, I think this will be better because there is no point admitting this petition. Let me send it back to the authorities. Whatever the grievance the petitioner has will be met.
But in the meantime, my lord, to protect the revenue, my lord, 7.5% deposited. Your lordship direct them to adjudicate within 4 weeks. They will do.
Very well. That I will.
At what amount? Let me put a question to myself.
Of the demand.
Of the demand. But of the demand is whole. This itself is statutorily prohibited. But the amount has to be
I am
calculated.
not
They did
paying
not do so.
interest and penalty. I am only disputing.
But once the money is deposited,
I
this
am
will
only
court
paying-
class. I'll never get back. Even if I succeed, I'll never get back. That's what my experience.
My lord, specific direction. My lord will be given the specific
But
direction.
what I can do, I can deposit, make a fixed deposit, deposit 5 lakhs of rupees, and deposit the fixed deposit.
What is the demand?
My lord, 1 crore 60 lakhs.
And then
1 crore 60 lakhs.
Upon what?
7.5% of 1 crore 60 lakhs. How much?
About 10 lakhs.
10 lakhs. Near about 10 lakhs. Less than 10 lakhs.
Let them deposit 5 lakhs with you.
Yes. In fixed deposit in my name, and I'm undertaking that it will be renewed.
With the endorsement.
With endorsement, I'll keep it.
Endorse it. Endorse it and give.
Yes.
Yes, yes.
Because once deposited, my client will never get back. This lady will die and she will never get back. Because I have a very bitter experience about these departments. And now I'm fighting a suit for realizing.
Whatever your givans are there, it will be made there. So let us not go into this issue at all. The present petition
May I, sorry, but same gentleman will hear or somebody else? Let them specify.
Why? Whosoever is there will hear.
So notice has to be given because there is
no further notice. I'll provide for you. I'll provide here everything.
It should be registered notice or speed post notice to my client. Mail.
Sir, I'll fix a date. You want to go there?
Lordship. Yes. Lordship, kindly. Kindly do that.
The present writ petition has been filed internally challenging the order passed by the Additional Commissioner Headquarter, Central Tax, CGST, within bracket Central Excise, Holdia, Commissionerate, on 29th February 2024 under Section 73 of the Finance Act 1994, herein after referred to as thereby determining the tax liability of the petitioner in terms of the show cause cum demand notice dated 20th April 2021. So, according to the petitioner, the aforesaid show cause is barred by limitation. Independent of the aforesaid, it is submitted.
No, my lord, that point was not raised.
He has submitted that. I will not record his submission.
My lord, that point not in the writ petition, my lord.
Maybe, but he submitted that.
It will extend, my lord. My lord, it will extend.
I will open
My lord, it will
I have to
extend.
record a submission, Mr. Maiti. When you make a submission, I have to record it. I cannot say I will not record a submission. That will be
But
unfair
that may be-
on the part.
That
If the lawyer makes a submission, I will not record it, Mr.
but
Vaidhi.
that which was not in the documents.
I
my
will
lord.
not adjudicate upon that is a different issue, whether I'll accept it or not. But what Mr. Ghosh submits, what you submit to tomorrow, if something is not there on the file, but you make a submission, I will not record it, simpliciter.
No, my lord. That is not, my lord. That is
Then what are you saying, Mr. Vaidhi? It is his submission. So that's it. It is submitted. It is independent of the above. It is submitted that since the petitioner had executed the works, executed government contracts, the petitioner are entitled to the benefit of mega exemption notification dated 20th June 2012, issued in exercise of powers conferred under section 93 within bracket 1 of the said act. By drawing attention of this court to the document appearing at page 42 and 43 of the writ petition, it is submitted that despite the executive engineer, PWD, Diamond Harbour Executive Engineer 1, PWD Diamond Harbour Division, and the Divisional Accounts Officer issuing a payment certificate. Confirming the factum of payment by issuance of a payment certificate on 1st September 2016 in respect of the works executed by the petitioner. The same has been overlooked, glossed over. This was there. Same has been glossed over by he is the authorized officer or the proper, he is the authorized officer.
Authorized officer.
By the authorized officer. Poster.
Showing the payment made by executive. Then
What is his finding on 26A's?
Yes, my lord. That is, your lordship will kindly come to show cause notice. What has been stated. My lord, page 46.
Yes.
2.1.1. Last paragraph. On the basis of information received by the department from CBDT for the year 2015, 16 and 16, the said assessee was requested to submit some relevant documents like profit and loss account, income tax return, Form 26A, sample copy of the output service bills, along with explanation clarification for the mismatch of reporting different value of service provided to different tax authorities for the financial year 15, 16, 16, 17.
No, that is all right. I know show cause notice is based on this. His finding in the order with regard to 26.
And your lordship will kindly come
page
to
58, he has said that.
54, 6.4.
No,
Sorry,
58, he has recorded.
Yes.
Then thereafter, what is his finding?
64, 6.4.
6.4, your lordship. 59, page 59.
Yes.
I find the allegation non-payment of service today.
The assessee only submitted. You can take.
No, সেটা পুরি In respect of the also notice, the said notice was submit to documents and was asked for clarification.
He has ignored that.
The said assessee only submit bills of statement, audit report, work. The assessee could not submit output service bills, ask for verification as per work orders.
Output service bills. What is this output service?
Output service mean whatever service he has provided to whom. He has to give the bill. I have provided this work to the
The final bill, the government will prepare that bill anyway. So he has glossed over this.
Yes.
Very well.
Output service
Glossed,
bills were
glossed over the same. So it is still further submitted that in a contract of this nature, ordinarily no bills are submitted. Full stop. It is the PWD authorities who prepared the bill as per the format provided, and the petitioner is required to sign the same. Full stop. Admittedly, in this case, the factum of payment by the PWD authorities, by the governmental authorities, in connection with the works executed by the petitioner, has been confirmed by the ওই নামটা আছে page 44 by the divisional accounts officer PWD, notwithstanding the efforts that the same has not at all been considered. Full stop. It is still further submitted that notwithstanding the fact that the show cause notice was issued by the Joint Commissioner of Central Tax, CGST, and CX Kolkata South Commissionerate, the final order has been passed by the Additional Commissioner, CGST, and CX Haldia Commissionerate. Full stop. The aforesaid, according to Mr. Ghosh, is an irregularity in procedure adopted by the respondent, which has the effect of vitiating the entire order. Full stop. Mr. Maiti, learned advocate, vitiating the aforesaid order, and the same should accordingly be set aside. Mr. Maiti, learned advocate, representing the respondents on the other hand, submits that the order impugned is an appealable order, and ordinarily an efficacious remedy is provided for by the appellate authority. On the issue of non-consideration of the payment certificates and on the issue of non-consideration of payment certificates, he submits that the petitioner was given ample opportunity by the Additional Commissioner, CGST, and CX Haldia Commissionerate to appear before him. Full stop. Notwithstanding the aforesaid, the petitioner chose not to appear. Full stop. In the facts as noted here in above, there cannot be any irregularity noted here in above. The order passed by the Additional Commissioner cannot be said to be irregular. Also, by drawing attention of this court to the, where is that observation that he has been assigned, which
Madam, that is at page
yeah, I get
58,
it. By
paragraph
drawing attention of this court to paragraph 6.1 of the said petition, said 6.1 of the order dated 29th of February 2024, it is submitted that the matter in that the aforesaid case was assigned, that the hearing of the show cause notice had been assigned to the Additional Commissioner by the Chief Commissioner, VDA he is order dated 16th of November 2022.
Signed on 18 July 23.
No,
16 November.
as per order of the
No, it's
assignment is original.
Then it was sent to him on 23 July 18.
Yes.
Assigned to
No, that is different. Undersigned
was assigned to the
was
undersigned.
assigned to the undersigned with the order dated ato
18
by the
July.
Liquidation by the zone such and such issued by the additional government issue as per order of Chief Commissioner. Original assignment order is by the Chief Commissioner.
Then it was assigned to him on 18.
Yes.
18th.
So that's it. And accordingly, the additional commissioner had taken up the matter. As such, there cannot be any jurisdictional error on the part of the additional commissioner in disposal of the above matter. Having heard the disposal of the above matter, having heard the learned advocates appearing for the respective parties, and having considered the materials and record, I notice that the show cause notice pertains to the year. Show cause notice has been issued by invoking the extended period as provided for in the, this is under the first proviso.
Section 73.
First proviso. As provided for under section 73 within bracket under, as provided for, as provided for in the first proviso to section 73 within bracket 1 of the said act. Full stop. It would appear from the aforesaid show cause that on the basis of the information received by the department from the Central Board of Direct Taxes for the financial year 2015-2016 and 2016-2017, that the assessee was requested to submit certain relevant documents, interiorly including profit and loss accounts, income tax returns, Form 26As, including output service bills along with explanation clarification for the mismatches in reporting different value of services provided to different tax authorities for the financial year 2015-16, 2016-17 and 2017-18. Records reveal that the petitioner, by a communication in writing dated 19th of May 2021, had afforded certain clarifications, including the factum of the petitioner providing services to the West Bengal government for the period 1st April 2012 to 31st of March 2014. According to the petitioner became entitled, according to the petitioner, in the light of the mega exemption notification dated 20th June 2012 issued in exercise of powers under section 93(1) of the said act, the petitioner became entitled to exemption for payment of service tax. Records also reveal that the petitioner had placed the payment certificate. Where is that recording? We just placed a
Page 58.
yeah,
What
yeah,
we have
59.
Page 58, 5.0.
No, 59 here. I find the allegations non-payment such and such. Here, supporting documents, clarification.
Audit report, internal input, payment receipt.
কি বলেছো? Now, payment certificates. Petitioner had submitted bill statements, audit report, Form 26AS, and the work order. According to the authorized officer, the petitioner did not submit any service bills asked for verification along with the work order. Full stop. Since the petitioner failed to submit original work orders for verifying the authenticity of the work, the authorized officer had refused, that is the finding, had refused to accept the authenticity of the work orders. Full stop. It is, however, not in dispute that payments had been disbursed in favor of the petitioner by the
Public Works
Department, as would corroborate from the documents appearing at pages 44 and 45 of the petition, 42 and 43 of the petition, dated 1st September 2016. The aforesaid, in my view, ought to have been considered by the additional commissioner.
It was not with them. Your lordship now direct them to consider.
No, it's there. It was filed by the additional commissioner. Full stop. By the additional
documents which has been submitted.
Listen, sir, what that is why I'm getting the benefit, your benefits, sir, your assistance, and that is why I'm passing it in your presence. It is easier. Ki bollam? To that extent, to the extent of non-consideration of the aforesaid order and glossing over the work orders issued by the government, since the same was not disclosed in original, I am of the view that that such finding returned by the assistant commissioner is perverse. Additional commissioner is perverse. Although there may be some dispute as regards there may be some dispute as to whether the petitioner had actually disclosed the aforesaid documents, disclosed particular documents. There may be some dispute as regards disclosure of all documents by the petitioner. However, since this matter can be, without going into such issue at this stage, I am of the view that it would be prudent to send back the petitioner to the respondents, respondents for reconsideration of the matter afresh, inasmuch as Mr. Maiti, learned advocate representing the respondents on instructions, has not denied the applicability of mega, has not denied that in appropriate cases has confirmed that in appropriate cases benefit of mega exemption notification dated 20th June 2012 can be granted. So in view thereof,
kindly keep other dependencies also open, because there are limited the law permits me. I can take it point.
Whatever
is
there,
expressing to 18 months, 5 years is maximum.
Whatever you get it, sir. I have recorded your submission, sir. I send it back.
And then is very well. Kindly.
I'm going to that.
Can keep all the points open for the as regards this calculation.
The petitioner is remanded back to the whom?
To the adjudicating authority, madam?
To the adjudicating authority, who shall dispose of the aforesaid show cause notice by affording an opportunity of personal hearing to the petitioner and or her representative, within a period of representative dispose of policy. Who shall hear out and dispose of by giving an opportunity to petitioner and or representative within a period of 8 weeks from the date of communication of this order, subject to the petitioner making a deposit or in the alternative securing a sum of rupees 5 lakhs
By a fixed deposit, Lordship will provide it
by fixed deposit,
of any nationalized bank.
by a fixed deposit, by securing, by deposit of a fixed, by deposit of a duly endorsed fixed deposit receipt issued by any nationalized bank unto and in favor of
The
the whom?
petitioner, but I will undertaking to keep it.
Unto and in favor of endorsement as per negotiable instrument, endorsement in favor of,
Gotcha.
in favor of
Assistant Commissioner, madam.
Assistant Commissioner, CGST and CX.
Or better joint commissioner issue the show cause. It might
No,
not
no.
be better.
Any, I'm not going into that because it has been assigned. Now, whosoever will hear will pass the order. That is a clean slate now.
Not then as an additional commissioner.
So it is made clear that all points. It is made clear that I have not gone into the merits. No, দরকার নেই। এটুকুনি তো গেছি।
So the additional commissioner will contain many things there. If my land fund provides, then we can obtain the fixed deposit. So
Sir,
there are
you
so
will
many
prepare a fixed deposit in your name, endorse it.
endorse it, Lordship. That's it. In
On
my
the
name,
back, you know the endorsement. It has to be endorsed. You will advise your client that they will endorse it and send it.
Lordship.
Unless it is endorsed,
That cannot be.
nothing will, what they will do with this fixed deposit? It has to be endorsed.
Additional commissioner. Oh, when I'm told there are so many additional commissioners. If they
এটাকে কেটে
provide
দাও।
the correct,
এটাকে কেটে দাও। You pay.
I'll do it, Lord.
No, you pay
But the
5 lakhs. 5 lakhs. This will create complications. You deposit with them.
That will never
The
be-
deposit as aforesaid shall abide.
Very well, we will come up with the endorsement in the name of
Deposit,
additional
subject to payment of rupees blank with the respondents.
Never get back.
The aforesaid payment shall abide, provide for that. The aforesaid payment shall abide by the decision to be taken by the respondents. With the above observation directions,
that
the application stands disposed of. There shall be no order as to post. Yes.
The amount is to be
In the
deposited,
facts,
that's the problem.
you could not get anything better. Yes, Mr. Mojumdar.
Kindly to mention item number 82 and 84. Mr. Banerjee is also here. It is that matter where, my lord, the DGCI is the tenant. Your Lordship,
Yes, sir.
But my lord,
You were there on the last occasion. Yes.
my lord,
Yes,
may-
yes.
May I just point out, my lord, second half, I have a matter fixed in court number.
Let me ascertain from him what is your instruction.
I have given them the mail. They are now allotting the brief. They have not done the allotment, so they will be. I will
Well,
be
kindly
taking
keep it on
Tuesday or Wednesday. In the meantime, I shall take instruction. And
Tuesday or
now-
Wednesday.
Let me called on then and that I'll ascertain from him. Your junior will
But
be
your
here.
Lordship
Mr.
will-
Who is appearing as a junior, he is
What
there.
did I say?
Today from 2 PM to
It will not be present, but sir, if you are not there, I adjourn it, but it will be there in the monthly list.
Very well. Very
He'll be there because he needs time to get instructions.
Absolutely, absolutely, absolutely.
So far as the other bank is concerned, Mr. Who is appearing? For
Nobody
the,
got
no, Mr. Chaudhary is appearing. Mr. Chaudhary was appearing. So I will not interfere so far as the bank is concerned. Since you are raising the demand, that is why you can't do this, sir.
I shall take instruction.
Yes, can't do this. Unless you say that the nature of the agreement is different.
Let me take.
Then you have to show the agreement.
Yes, I have to take.
Oral.
On the basis of same agreement, they are paying GST. convert the order under section 148A(d), an assessment, into an order, into a show cause notice, and directors are to respond to the show cause notice and give us an opportunity of hearing, but that order is yet to be uploaded. It was passed by your lordship on last Monday, but it is yet
Identical matter.
identical matter. We may give the dates. The dates are slightly
Only different assessment here.
assessment here, and the some one or two.
Very well.
Can we give
show me just
Okay, well, I'm so sorry.
just show me.
Kindly take the show cause notice. Your lordship will find
এই ওটা না
show cause notice is dated.
তুমি জানবে না ওটা এটা হয়ে গেছে সোমনাথের কাছে আছে আজকে কমপ্লিট সই করে দিয়েছি
Date 32 is the SCN, the show cause notice.
আনাও না সোমনাথকে দিয়ে আনাও না এখন আনাও না একবার অর্ডারটা আনাও হয়ে গেছে Yes.
Page 32 is the show cause notice. The assessment year in this case would be 2016-2017. The date of show cause notice is February 21, 2024. And my lord, the order had been passed on reply.
Assessment year is 16-17. That was
16-17.
17-18 perhaps.
No, 1920.
19-20.
That was 1920. My lord, the show cause notice is dated 21st February 2024. And my lord, the order has been passed on 20th March, right? 20th March. Where is the order? The order is dated 20th March. Am I correct? Yes. 20th March 2020.
Can you give the number to my officer?
Item
other
number
matter-
78. 79. Oh,
79.
the lordships, it was item number 78.
No, read petition number.
Oh, read petition number. I am right now giving the other matter. 9978.
Of 2024. 9978. লিখে নাও শাশ্বতকে জানিয়ে দাও আনি না ফাইলটা আনো 9978.
Monthly item number 78.
এই নাম দিয়েছি
Identical, my lord. Word for word.
No, just show me section 69(8).
Very well.
Was there any show cause?
Yes.
That is the relevant
Absolutely.
consideration.
9978.
page 68 top.
My lord, lordship
No,
is
show cause is at page number 32.
kindly take page 39
Yes.
straight away. এটা আমি ঠিকটাই দেখি।
Not that I am doubting Mr. Mojumdar, but I need to see this.
No. It's absolutely matter. মানে revenue matter,
I need to
one has to be, even we may falter. মানে there is no doubt about it. মানে 39 at the top. Now, Miller, the reply to SCN, your
No,
lordship
not
will find
necessarily. Show me the order.
the order is at page,
Final.
final order is at 49.
No, 49 it starts.
And 68 is the
Kindly take the conclusion drawn at paragraph 4.3. And your lordship will find at the end 66. 66.
Oh, here 66.
66. Taxation impact. না আগেই
Under 69A.
from
No, the
section
penalty is 69.
no
To
the
69
first
AST, the total amount of cash loan given to lender is liable to be taxed under section 69A.
69A, and then the addition has been made that your lordship will
115B.
BB.
What is this?
My lord, this is a special provision for my lord, for when additions are made under section 68, 69, 69A, 69B, 69C. Then my lord, a special rate of tax is imposed.
So this is consequential.
This is consequential.
So even if 68 instead of
Even
68,
of
69 is
68,
there,
absolutely,
this would have. So there is nothing to do with
There is
this.
nothing.
So only 60 instead of 68,
It would be 69A
Yes.
as it was there in that case.
and here the amount is on account of cash loan.
Same, identical. Word for word, my lord.
The amount is different.
Very well.
clear only one thing. In all the orders, my name is coming wrong.
But his
kindly see.
name has been recorded as Orko. But he is Arjok. I told him there's nothing to
No,
worry
no,
about.
I did not notice it. I did not.
But there is nothing to worry about. It's good. Well, Arjyo, the Lord of all Arjyo Putra, the Lord son God. So, আমার তাতে কিছু করার নেই।
It will be corrected.
So this is it, Mala. This is it.
So, Mr. Dad, you see, you have so many names. It will be corrected.
And he is feeling happy about it.
Hey, এটা সেম ডিসপোজটা ডাক দিয়েছে ওইটা শুধু বদলে আমাকে দিও কপিটা বের করে দিও। আচ্ছা এখানেই আনবে এখানে শুধু আনছি ফাইল জাস্ট 1 মিনিট।
Yes, yes.
দাও ওটা দাও ফাইলটা দাও
কাভারটা? না না, এই নে কাভারটা। এই ফটো বলতে আমি দিয়ে দিচ্ছি।
একেবারে ওয়ার্ড টু ওয়ান এক কি হবে এখন কোটের বলার দরকার নেই। Where is your affidavit of service?
Affidavit of service দাও।
You don't want to file it?
Last location I have to. দেখো Yes, madam, the affidavit of service.
Very good. On the same terms. The direction that I've passed, I'll just clear it.
Yes.
Was passed in your presence.
Your lordship was pleased to direct that the
order dated such and such be treated as a show cause.
Right.
This, however, shall not prevent the respondents from taking any additional point or raising any additional grounds,
right,
if so advised.
Right.
In such case, however, a notice would be required to be served as an addendum to the show cause to the petitioner. Such addendum, if any, must be served within a period of 10 days from date. The petitioner shall respond to the aforesaid assessment order dated such and such by treating the same as a show cause within a period of 2 weeks from date. If, however, any addendum is served, the petitioner will get additional 7 days time to respond to the same. For the aforesaid purpose, the faceless assessing unit is directed to ensure that the portal is activated for the petitioner to submit its response, appropriate response. Needless to note, before finally deciding the matter, the faceless assessing unit shall afford an opportunity of personal hearing by sharing a video link on the portal. The entire exercise in this regard must be completed by the respondents within a period of 8 weeks from the date of communication. Your time is also very limited to put in that addendum. It will be uploaded today. So you'll get maximum of another 3 days have gone, so 7 days time you'll get. If you want to put in an addendum, if you want to,
Not required.
not required. So, but I have not prevented you by following that observations made in that judgment. Although it is not very clear, but it can be inferred from that. That was the consideration for
whatever
which Supreme
direction
Court.
your lordship has passed in this matter, the authority has every power to do so.
Yes. No, the High Court
Yes.
said it could not.
Yes.
That the Supreme Court
That the Supreme
corrected.
Court needed, no, it
In
can
its
be
own
done.
language, it corrected in that fashion. Yes.
When I had informed the department about this order, the only thing that I was told that you may request some time for the faceless to have communication with the faceless, because the assessment order has to pass by the faceless.
I provided for that.
But your lordship has given 8 weeks time, that is enough.
I think that is enough. Outer limit is very high. But internally, for response purpose, limited time should be given.
Yes, yes, yes.
Applied.
Obliged.
Next.
Now only my name.
No. তুমি চল, তুমি বাজে কথা বলে
হয়ে আজ হয়ে সই করে দেবো দিয়ে দেবো তোমার দেখে করো
Item number 82. 82.
Yes, where is Mr. Banerjee?
Yes, Mr. Banerjee.
Yes, sir.
Actually,
Mr. Chaudhary, for you, this matter was adjourned. Because in the morning, Mr. Mojumdar mentioned the matter. So I could not take up this matter because you are there. And you were not present then.
I was here, my lord, I was just outside speaking. Because at that point, 120, 130 was there. So that is the
It's
reason.
all right, Mr. Chaudhary. When you want it?
okay. So we are getting it fixed.
Monthly list, I'm sending it because Mr.
Monthly
Banerjee.
list, monthly list.
I'll just adjourn it.
Yes.
Because in the morning he was there. He sought for an adjournment, Mr. Mojumdar, he sought for an adjournment.
Yes, he sought. I'm not opposing.
I'll place it.
Because
the learned advocate representing the otherwise, it
Mr.
will not be
Banerjee was
recorded.
there.
He was actually there.
Actually there, my lord. Mr.
So that's why
Banerjee.
recording his appearance. Mr. Banerjee, learned advocate representing the CGST authorities, prays for an accommodation to take appropriate instructions in the matter. In view thereof, let this matter stand adjourned and appear in the monthly list of July 2020.
I'm so grateful to you.
Just remind me when the matter is
We
taken.
will. Definitely. 82 and 84.
82 both.
Both.
82
and 84.
My lord, in
আচ্ছা আমাকে একটা ইয়ে এনে দাও তো Yes, you are there. The matter.
109.
State, my lord. State. Yesterday, this matter was adjourned, my lord. State.
State appearing, my lord, not income tax department.
State, my lord. Oh, yes, my lord. My lord. I know them, right? I understand. My lord, I'll request your lordship to come down to page number 29, my lord, once. But 29 is the demand order. DRC 7 is a demand order. This ought to have been appealed against, my lord. Well, the appeal has been filed, my lord. It is in page number 36. And the running page, my lord, 37, 38, my lord. My lord, item number 18404. My lord, 36 is the appeal, my lord. And it is ending, my lord, not ending, my lord. Basically, it is, my point is in page number 38, my lord. It was made. But there was a delay. There was a delay in filing the appeal. This was the, my lord, 73 days, my lord, if I exclude that 1 month grace period of this 3+1 month. And my lord, the reason, my lord, page number 38. Before the verification, my lord, the last column verification, above that, my lord, medical certificate PDF, my lord. Thereafter, my lord, but it was adduced. I'm placing, my lord. I'm placing. But thereafter, my lord, the grounds and page number, my lord, 51, my lord. 51. Item number 17, my lord. Well, excluding that, including that 1 month grace period, my lord. If it is excluded, that it will be 172, my lord. But it starts, the order starts from 12/7/23, my lord.
And my lord, the medical certificate is in page number 56. My demand is, I have already paid my lord 10% of the demand. Demand is my lord page 16 lakh, my lord. On payment of 10%, the demand was, the appeal was admitted, my lord. Otherwise, my lord, 16 lakhs, my lord, 1,60,000. 16 lakh, 1,60,000, my lord, paid.
Engage my senior TM Siddiqui, engage court number 8, engage. TM Siddiqui, Mohammed MD TM Siddiqui.
Mr. Chakraborty. Someone to come here. Yes.
Well, in page number 56, the medical certificate is admissible. And another point was, another point which I am agitating is that the notice as regards to the this order in original, my lord, it was not in the portion of the portal meant for posting the orders, my lord. It was in the additional orders, my lord. Now, I say that this is not a good service. My lord, there are authority of judgment as well as our Chief Justice has also passed the judgment upon this, my lord. My lord, what is my submission is, whether the notice ought to have been pasted, my lord, or have been posted, my lord. But this is an allegation which I am making, that the notice was not in my visibility, my lord. But first, judgment of S.K. Chakraborty as well as your lordship's judgment, my lord, of the your lordship judgment, my lord, and thereafter, my lord, the last judgment is passed by lordship's Chief Justice Sivangan, my lord. Well, lordship, if takes up the matter, my lord, of on how the impacts Nahad impacts, paragraph number 2, 4, 5, 6, 7, 8 is the Anhad impacts, my lord, Delhi High Court, my lord. Paragraph number 2 is the issue, my lord, in hand. But learned counsel submits that the so-called notice were normally uploaded on the portal. Third line, my lord. Learned counsel submits that the so-called notice are normally uploaded on the portal under the heading notices. However, in the instant case, it appears that the so-called notice was uploaded on the portal in the category of additional notice, which were not easily accessible. But thereafter, paragraph number, my lord, lordship has division bench has taken cognizance to judgment in paragraph number 6 and 7, my lord. And thereafter, the operational part of the order is page number, paragraph number 9, my lord. Here use the impugned orders, shows that the impugned order category records that the taxpayer has not relied or appeared in person. Consequently, we are of the view that the petitioner needs to be granted one more opportunity to respond to the so-called notice, my lord. In the additional notices, my lord. Yes, my lord. My lord, I have the. My lord, I have filed a supplementary, my lord. My lord, condonation of delay, my lord. Yes, my lord. My lord, in the application for condonation of delay, my lord. My lord. My lord, two different things, my lord. One was medically unfit, my lord. My lord, medically unfit, my lord, and thereafter, my lord, page number, my lord, 52. 52, yes, my lord. My lord, 53, my lord. My lord, 53. That a petitioner not being a tech-savvy person came to the knowledge of the instant judicial adjudicating proceeding right from the date of issuance of 01 dated this until the issuance mail in this received on this for recovery of tax this for recovery of demand for or on account of the petitioner only after the petitioner was acquainted with the fact, my lord. The petitioner was surprised to find that the adjudicating authority has proceeded with the instant proceeding leading to issuance leading to issues such as adverse order without following the principle of natural justice and providing a reasonable opportunity of being heard to the petitioner. This is the reason, my lord. My lord, my lord, my lord, my lord. My lord, my lord.
But paragraph 7 says otherwise in the writ petition. Paragraph 7 and 8, my lord, it simply says on so and so issued a notice in 01A and thereafter in 8 on 08/6/2023.
My lord, in the supplementary I have taken in the supplementary, my lord.
Cannot be.
My lord, I have handed it over. Well, yesterday it was given to them, my lord. Yesterday it was given to them. But it is service achi. Supplementary कोথায় গেল? One moment. No. My lord, I had already categorically submitted before the authority that there was a violation of natural justice. You are saying such type of I said supplementary.
The averment at paragraph 3 of the supplementary is the impugned notices and orders were not served physically upon the petitioners and uploaded. That is it. এটা তুমি এটা না দুটো তোমার
Well, paragraph number 3, my lord. Paragraph number 3, my lord, categorically, my lord, the impugned notice and order were not served physically upon the petitioner and uploaded only on the GST common portal, that too peculiarly in the column meant for additional notices, my lord. My lord. Well, I took the plea of, my lord, my medical fitness, my lord, and thereafter the principle of natural justice, which is, my lord. No, no, my lord, also the natural justice point was taken, my lord. Principle of natural justice was not given to me, my lord. It was not followed, my lord. It was also taken, my lord. Last two lines, my lord, of the condonation, my lord. Delay prayer, my lord. The petitioner was surprised that finding that the adjudicating authority has proceeded with the instant proceeding leading to issue certain adverse order without following the principle of natural justice and providing a reasonable opportunity of being heard. My lord, my lord, if this is the
What is the consideration?
My lord, my prayer is twofold, my lord. First of all, that as because principle of natural justice was violated, my lord, I need to be put back on the same shoes, my lord, before the so-called notice was adjudicated. And second, my lord, if at all, my lord, my appeal is, my lord, all the judgments is in my favor. Even the Chief Justice, my lord, has passed the judgment.
What are you challenging?
My lord, twofold, my lord. One is my appeal to be allowed, condoning the delay, my lord, or otherwise adjudicating order to be quashed, my lord, and I put. Well, I did not get a reasonable opportunity of being heard, my lord. I did not get an opportunity of being heard, my lord, as because the notice was not in front of me, my lord. My lord, a notice is to be pasted.
Lordship will.
Or will it survive by order?
No, I leave it to Lordship. I am a little handicapped because this matter will. I am not there in this matter. Otherwise, I represent. Lord, may I take a day's time, Lord? Lord, Lordship will, Lord, in the appeal order, Lord, they have appeared. It's not that they have not appeared in the appeal. In the appellate order, my lord, at page 58, my lord.
My lord, my lord,
Cannot go out of there.
my lord, but my record also says otherwise, my lord, that if I did not get an opportunity of being heard, my lord. My lord. My lord, I'll be. My lord, I'll be also happy that it goes to the appellate authority because 1,60,000 has been paid, my lord.
May I only pray for my lord short passover, my lord, Mr. Shoptuk Channel or my lord, Mr. Siddiqui, my lord, if I can find them, my lord, or I will come back.
Well, it is already 2:45, my lord.
Yeah, I understand.
Waiting for 3 days, my lord.
Then tomorrow first, my.
Filed by the petitioner under section 107 of the West Bengal GST stroke CGST Act 2017 and be rejected. Appeal down. Had been rejected.
Snehangi Traders. What is the name of Snehangi Traders?
Has been literally compliant. Was served. The first notice.
Page number 12 July 23, my lord. Page number.
Respect of the tax period July 2017 to March 28. Under section 73 of the same act. Eligible short payment, stroke non-payment. Respond to that. No.
My lord, no, my lord. As this notice was in the additional notice column, I did not come to know about as the customers. My lord.
Same culminated. Same culminated in the 12 July 2023. Passed under section 73(9). Say that. The petitioner, however, needs to be aware regarding the above and such time a demand for recovery of tax under section 79 for recovery under section 89 of the state act was served on the petitioner email ID on 29th October 2023. Petitioner had recorded an appeal for an appeal. Section 73. I've only taken the facts.
There have been instruction in this matter. I don't know whether it is that GST IN is the responsible because they have tried to upload it because department doesn't have the power to upload it.
What I'm saying is there. There is an appellate forum. We get an opportunity to do that. Although we agree the petitioner had preferred an appeal. The appellate authority under section 107 of the state act and also need to remain as required under section 106 of the state act. The state authorities appeal was accompanied by an application by a detailed application. According to the petitioner, there was a delay of 23 excluding the prescribed period, excluding 4 months or 3 months.
2 months. 3 plus 1 month.
Prescribed period and a month thereafter. 73 days, excluding 4 months. Period, according to the petition, that is attribute. Is attribute then the delay according to the petitioner had operation by the petitioner. With regard to the factor, we have not had knowledge. Factor with regard to the factor of influence of the benefits of the so-called or with regard to the factor of mass of the order of the jurisdiction. By drawing a statements made application of confidential rate includes submits that not only because police are passed under section 79 of the state was uploaded to this section. What was uploaded additional notices and orders.
New additional notices.
New additional notices and orders. Section of the petition that we are aware
software.
Steps. Certificate issue, medical certificate issue, qualified judgment delivered by the Honorable High Court of Delhi and New Delhi in the case of its partners versus Assistant Commissioner Law. In similar set of in a similar case, where the notices, where the order was uploaded on view on view the Honorable High Court of Delhi and New Delhi was entirely pleased to set aside the same and remand the matter back to the authorities on the ground that the petition on the ground that the assessee had been accessible.
Yes,
from responding to the said notice, which constituted from responding to the said notice by use of lack of knowledge, which constituted violation of principles in the order by basic accounting had been implemented from responding to the said notice, but the applicant authority by ignoring, by glossing over, by ignoring the case laid out by the division and purported to indicate the said appeal on the ground of the petition. That there was no petitioner highly appeal beyond 1 month of the time prescribed. While the appeal within the time prescribed. Order passed under section 69 cannot be sustained. The same is to be set aside and opportunity should be afforded. Respondents have not told
Over the
as to where the notice and the order shall be uploaded. Thus, the aforesaid notices and or orders are uploaded by
GSTIN. I don't know whether they have made them a party or not. Your Lord. GST network. GSTIN network. IN network. Getting to network. What a family. Someone instruction.
GSTIN. I'm not a party.
It's not a party here.
As such, without making GSTIN a party, two orders should be passed. Anything else, sir?
It's GST and there's a certain confusion, Your Lordship. GSTN.
Merits or the merits of the appellate court's order, what we
Merits, I don't have to say anything because only the additional show on this nomenclature because they are what.
Well, that is not a fact, my lord.
I cannot display. I cannot improve whatever
That is not a
instructions I have.
Well, I am not.
I'm upon instructions. I am not. I'm upon instructions. I am sorry.
The supposed notice under section 73 dated to the architect and the petitioner contains the petitioner did not get opportunity to respond to the same, since the same was not uploaded. Section, you notice a section stroke tab of the same uploaded, since the same was not available or being downloaded, but all this is tab. Footer. Gather on the footer. In fact, by difference of feedback, in absence of any response being filed by the petitioner, the adjudication order under section 73 of the State Act was passed by the proper officer. Incidentally, such order was also not available in the section of the order, and the same was available. The same was only available.
View additional notice. Additional.
Notices. Yeah. The petitioner, I find that the petitioner's case that by reasons of the aforesaid petitioner claims that it had acquired knowledge to the quantum of passing of the aforesaid order from the email communication dated 29th of 2023, connection with the notice issued under section 79 in connection with case for recovery of tax issued under section 79 of the State Act. I find that it is also a matter of record that petitioner has prepared an appeal and had also taken the deposit as required under section 176. A detailed explanation as to why the appeal has been filed out of time. The opposite aspect, unfortunately, has not been considered, appropriately considered by the Additional Commissioner of Revenue, Appellate or by the Appellate Authority, has proceeded mechanically observed that inasmuch as the petitioner had filed the appeal after a gap of 6 months and 12 days, there was no reasonable cause for the delay. Although Mr. Churadia learned advocate petitioner by placing reliance on a judgment delivered at the High Court of Delhi, by placing reliance on a judgment delivered, unheard impacts supra by the Honorable High Court had tried to impress upon this court that the initial determination made by the proper officer under section 79 of the State Act cannot be sustained by reasons of failure of principles of natural justice. I am of the view that it is too late in the game for the petitioner to challenge the same before this honorable court in exercise of its jurisdiction. After having filed an appeal under section 130 of the State Act. Since the petitioner had already approached here, I however noticed that the appellate authority had mechanically rejected the petitioner's application for promulgation of petitioner was prevented from filing the appeal within the time prescribed has not been considered within the time prescribed by reasons of lack of knowledge, connection with passing of the aforesaid order has not been considered by the appellate authority. The order in appears to be perverse. The same is perverse. Yes, you know. I mean, it may be relevant. No. The appellate authority has to authorize documents. It's not that it has already been held by the division bench for in case of held by the honorable division bench of this stage order to be advanced as a superior of India. Cases unlike that, separate by that, where the appellate authority is forbidden to admit an appeal by the honorable division on one of our prescribed as provided for in section 10. Say that having regard to the aforesaid, I am of the view that the order dated 27th of February 2024 by the appellate authority cannot be sustained proceeding the amount of the said. Having regard to the explanation offered by the petitioner, I am further of the view that no purpose will be served to be unfair the matter of the question of continuation or delay. The appellate authority, the explanation provided by the petitioner appears to be sufficient. By concluding the delay, I rest by concluding the delay, by concluding the delay, I direct the appellate authority to clear out and dispose of the appeal. Clear out and dispose of the appeal. After the opportunity of getting of 8 weeks from the date of publication of wisdom for the opposite purpose, the appellate shall share a equally.
No, proceed.
Great production.
Because what this matter is very serious.
Game is going on. That's why.
In fact, in the case of Provisional and Jaju, my lord, on our division bench, my lord, the similar order was passed, my lord.
Whereof since the appeal was preferred and substantial amount was recovered, my lord, Lordship Sivangan has passed an order whereof the appeal was restored. Grateful, Lordship. And that order has been handed over. That order has been handed over.
Original side, item number 1.
My lord, may I be permitted to mention, my lord, item number 137 of your lordship's daily list. My lord, my lord, your lordships on the last date had indicated that perhaps in the month of July, your lordship. My only submission is, my lord, may kindly give some precedence. My lord, yes, kindly, grateful.
Lordship, item number 1 for the petition, this matter pertains to Group 9 matter, and your lordship does not have determination, so may it be released, your lordship. It was missed. Your lordship, it was mistake on my part. I had mentioned it for non-prosecution. Later on, I checked it as a Group 9 matter. I apologize for the mistake, your lordship.
The matter pertains to this matter.
No, একটা আমি দিচ্ছি।
Item number 2.
Item number 2, my lord, this has come at my instance, my lord. My lord, this has come at my instance, my lord. This the company petition has been assigned before your lordship. But this is
All
connected
dulled up matters, my
applications.
lord. I'm for the official liquidation.
Lordship, a very short submission, my lord. The applicant before your lordship the application is being filed through a legal aid, my lord, High Court legal aid. Lord, may I file the affidavit as a reply? My lord, his retirement dues are due. Lord, that, my lord, the official, we had submitted our proof of claim where official liquidator turned down. Against that, this appeal has been preferred.
No.
Now,
It has
my lord,
not been turned down, my lord. Already 1,25,000 plus 30,000, he has already received it. And maybe he is not properly instructed. Pursuant to the order of Justice Bhattacharya, your lordship. On 2 occasions, there was 2 orders passed in respect of making the payment to the workers, my lord. Keeping a ceiling limit of 1,25,000, and there was, and the 2 orders passed, my lord. That is,
my lord, may I just place my application?
2nd of November 23. That is for 30,000 to be paid on pro rata. It is all on the pro rata basis, on the subject to the availability of the fund. No, not at all, my lord. They've all been exhausted because there are 2,250 workers, and already pursuant to the lordship's direction, your lordship, on 2 occasions the payments have been made to those 2,250. Those are all ad hoc payments. Those are all ad hoc payments, my lord.
I have not been favored.
Let all the other properties be sold off.
Lord, let some payment, whatever the admitted amount be. My lord, I understand. My lord, if there is a pro rata. Lordship.
Because already the payments, whatever has been now, they are running out of funds, my lord. They cannot make any payment. Yes, he has received it. He himself, he can admit.
No, let Lord, they have filed their affidavit in opposition.
No, no,
So that-
subsequently,
let
this
them
has
show
been
that.
filed much prior to it, my lord. But there wasn't two orders, that is of November 23. No, judges summons, these are all the matters of
nothing is-
22, my lord. This is a matter of 22 and the orders have been passed.
Lord,
20th
subject to
of,
correction, Lord,
November
after
22 and 22nd of November 23, your lordship. On two occasions, the payments were supposed to be made. And my instruction is that he has been paid 1,25,000. Maybe there is a balance amount due, my lord. Yes, my lord.
Lordship. Lordship. Lordship, it is there in the, Lord, with the affidavit of service, Lord. Lord, from 2022, Lord, I am suffering, Lord. I have not been. Lordship kindly takes, Lord.
Because
Lord,
whatever
pay-
submission I have made, it's
Lord,
upon instruction. And if he has not at all been paid, my lord, that 125.30 he will be paid. Yes. Yes, my lord. I shall come back with that. I can come back next Thursday, my lord.
No, but it was a VRS, it was, the company went into liquidation.
No, next Thursday.
Next Thursday.
Item number 3.
I'm for the official.
Reply to
No, this is the central bank is the applicant, my lord. And for two has been, my lord has passed an order in item, yes. First one, first one, but different matter.
Go out
First,
of list.
oh, go out of the list.
In this matter, as your lordship know, company has gone into liquidation and claim was invited. Well, company has gone into liquidation, my lord, and claim was invited by official liquidator, to which central bank has lodged its claim for a sum of rupees 171 crore and odd amount. Official liquidator has admitted claim to the tune of rupees 51 crore and odd amount. And thereafter, yes, claim is admitted, and thereafter it appears from the letter of official liquidator, they have collected a fund of rupees 53.31 crore, but no disbursement was coming up. As this application was made, Pursuant to the filing of this application, official liquidator has disbursed and paid to the Central Bank of India 18 crore. No, I'm saying a fact. This is for 18 crore. Now this matter was directed to appear in the list.
It is not required, my lord. 18 crores have been paid to the central bank pursuant to a court's order, my lord. Maybe there are
my lord.
Month of July. নাম লিখো না
Yes, ma'am. For the balance amount, this matter was directed to appear in the monthly third week of March. Sleep living.
my lord, to be very candid, my lord, already 18 crores have been paid. Now there is no money. They're running. But until unless the assets are being sold, my lord, out, because these are all the payments have to be done from the sale proceeds. Official liquidation is out of fund, my lord. They cannot even make the payment.
Tomorrow.
month of July.
Monthly list of July.
Item number 4.
This is also a same. This applicant is also a worker and now coming up with the plea of making the payment. But I believe in this particular, yes, in this particular applicant has not, I think so, he has not received that 1,25,000 or 30, whatever.
This is a fresh application, my lord. No payments have been received.
So they can produce the bank details before the official liquidator and the payments will be made. If at all not.
Page 30 is the first order, my lord.
45 and.
Page 45 is the second order, my lord, giving 30,000 rupees.
And
the first order
1,25,000 is the ceiling limit.
25,000 rupees, my lord.
Official liquidator. It's a
Yes, my lord. Yes, my lord. My lord, that's at page 20.
official. My lord, this can be disposed of here and now because if they can produce the bank details and everything, and then this 125 and 30 can be paid, not the entire amount of the admission. then I shall bring a written instruction to be kept on record. Easier.
Grateful.
On next Thursday.
Grateful, madam.
না না আগেরটা আলাদা একটা হেডিং সবগুলো আগে একসঙ্গে হয়েছে
Matter number 5.
Series of matters which appears to be of the workmen.
No, this is the 5 is a different.
5 is a different matter, my lord, about the workmen.
5, I believe, Mr. Shakoshan was appearing in this matter, but I want to file an affidavit in this. So let there be a direction for filing an affidavit. From 6 onwards are the application of the workers.
Item number 6.
Item number 6 to item number 85. 6 to 85 are applications filed by the workers wherein first tranche of payment of 1,25,000 and the second tranche of payment of 30,000 have been paid. But this is in respect of the all workers. All 6 to 85 are all of them are workers where under 529A the official liquidator has admitted certain amount. That amount out of which that amount of around 1,25,000 and 30,000 have been paid pursuant to orders passed by this honorable court. That has been paid by the official liquidator to all the other workers. Now, this is the set of application wherein there are certain balance amount which is still due and payable. So
that balance amount cannot be paid now unless the assets are sold because they are running out of fund, my lord. They can't be
your lordship
paid now.
kindly considers only one thing. I'll just
These matters have to be kept in abeyance because I cannot make any payments now.
Only one thing, if your lordship kindly sees only one thing in the chart, I'll just indicate only one thing. What I have done in the chart is that I have indicated the admitted amount, which was admitted by the official liquidator by giving a letter to us. We have made the claims, supposedly if your lordship kindly considers the first case. Yes. No, I completely bow down, my lord.
Yes. I don't have.
I'm not passing any order to me. Let me ascertain what are the other applications.
Very well, my lord. Because under 529, perhaps this preferential payment. Very well, my lord. Very well.
So workers will not be deprived, my lord. They will get their money.
Because this is really a meager amount of 20,000, 30,000, 50,000 which have been paid.
And very
some of them are into lakhs, but
an application before your lordship for the sale of the assets.
If your lordship sees the chart, very well, very well.
85, up to 85.
Very
good. This set of workers application. No, I am appearing for a contributory. I have filed an application for review, but that is set aside. That is pending. Keeping that aside, my lord, I had filed an application with the official liquidator to let me know what are the admitted claims. Now, my lord, I heard, my lord, that these claims are admitted. By a letter of 1st February 2024, official liquidator has written to me that no claims have been admitted as yet.
Yes. So that's part of our records also.
So, no, my lord, what I am saying is this. Under the company code rules, any contributor is entitled to call for the list of claims which have been settled. They do not provide that. No, I have not filed an application. My review is pending.
Oh, no, it's a different.
Very well. I take out an application. It should not be, that claims are being. Please.
Item number 86.
86. My application, the Dunlop knows has gone into liquidation. Dunlop has a property by the name of King's Court. I own half of it. I'm Salazar, I own half of it. Chorungi, 36B Chorungi Road. Yes. Salazar owns half of it and Dunlop holds half of it. Dunlop went into liquidation. There was a right of preemption, which was there already in the original deed of purchase. Salasa. I made an application to court saying that there's a right of preemption. It should be sold to me. The court passed an order in 2021 saying that very well, your right of preemption we are preserving. The official liquidator will advertise and sell the property. Whatever the highest price, you will get it at that. So my right of preemption preserved as well as a sale. Now, the sale was trying to be conducted. The court issued notices with regard to sale. Then another entity. Well, naturally, that is what is happening because the court said official liquidator will sell by advertising. So whatever the highest value comes, I will. That's the order. That's already an order. Correct. That's already an order. Now, my learned friend appearing for eyelid. Yes. Only King's Court, not properties of. Yes, provided I match. Then, my lord, eyelid. A company called eyelid, for which I think, my lord, Mr. Ghosh is appearing. They made an application saying, no, Dunlop actually had sold this property to me long back. And I had paid consideration. That's what they say. And they made an application saying that it can't be sold. Malad went up to the division bench, all that happened. Now, Malad, those two applications have to be heard. This is Malad where we are. There is no deed of conveyance. eyelid doesn't show a deed of conveyance. Sorry, Malad.
Specific performance of
No agreement. No agreement. He says it's been sold to him.
Agreement for sale is there.
He said it's been sold to him.
By dint of
possession has not been given.
No, possession. Dunlop was always in possession. And Mullah, that's what Mullah, the orders are. Mr. Ghosh, my lord is not deciding it. Running commentary ka pade do na.
So, there is according to Mr. Ghosh, there is a substance sold. Sold by
Dunlop to me.
Sold by Dunlop to him.
So the interest of Dunlop has been.
That's right. That's what he says. And this is Malad gone up to the division bench. I'll show all these orders where Malad some comments have also been made on Mr. Ghosh's client, quite naturally, Malad, because he's appeared Malad after Dunlop has gone into liquidation after 20 years. He comes and says, no, sorry, I'm actually half the owner of the property. This is Malad where we stand. That subsists. Yes. That is Malad. Yes.
That has been passed into liquidation.
Yes. On my application, 3rd February 2021.
No, I have asked for.
There is no charge.
I've asked for.
And it, Malad, I'll show the. Yes. Independent in the liquidation proceedings itself. That is why it is, Malad. I don't know whether independent would mean, Malad. It is in the liquidation proceeding, has to be. Yes. That's right. That's right. Correct. Correct. And I will show Malad there are subsequent orders whereby Malad he was directed. eyelid was also directed to participate in the sale. Yes. And Malad very interesting. Malad very interesting. In applications confirmed by the division bench, eyelid has been directed to participate in the sale. So, Malad, if he is the owner, I don't know how Malad he participates in the sale, Malad, for purchase of his own. No, in application, in his application, Malad, I'll show that, including division bench. After division bench order, just
in my application, I will just interject. In my application, notice of sale is also under challenge.
Whatever is under challenge, Malad will consider it. Okay, দেখা नहीं बोला কত ডেটটা বলো 19 December
notice of sale is under challenge. But I will only explain this, my lord. His rights, if any, percolates after my petition.
Malad, kindly look at this order, Malad. 19 December 2023.
Sorry, my lord. Yes, sir, I asked for a stay of that also. Yes. My lord, it cannot be because for the simple reason he's saying he has got a preemption right. Out of that, he has got the right to go in a auction. The auction is subject to my application.
Yes, yes.
Yes. Yes.
Of the order that was passed.
Passed on 6th of September. 6th September 2021 order.
3rd February 2020.
6th September. My lord, on 20th September 2021.
3rd February has not been challenged. My lord looks at the order which I've handed up. This is the last of the series of orders. 19 December 2023. Yes.
That what plans for another language what
Yes.
therefore treaty
Yes. Correct. What has fallen for absolutely correct.
Yes, I am also saying Dunlop was the owner.
No, was and is and what the difference.
সেটাই তো সেই জন্যই তো আমার অ্যাপ্লিকেশন
that your client is the owner of it.
Yes.
Because Dunlop has transferred its interest in it.
Yes. Yes.
Dunlop.
Yes. Absolutely.
But the fact is the passed an order treating Dunlop to be the owner. That is subsequent to your alleged acquisition of interest. Is it correct?
But that is not sought for recalling.
No, you haven't sought for
I'm saying the notice of sale to be stayed, set aside. And the order of 6th September to be recalled. My lord, I will show documents where my Mr. Banerjee's client himself says I am the owner.
No.
I will show, my lord.
Yes, yes.
We can
have
laugh
seen
it
those
out, but it will
documents.
obviously the honorable court will assess.
My lord, may I just show just two pages, my lord, what I've handed over. Kindly look at page 5 of that. Just kindly look at that. Mr. Rupak Ghosh, learned counsel appearing on behalf of eyelid mercantile private submits that eyelid is the 50% owner of the property in question, which is now sought to be sold by the official liquidator. My lord has seen that, my lord. Internal page. Then, my lord, kindly come to page 7. Page 7. This is a division bench order. In so out of, my lord, the sale itself. Because, my lord, I got an order. Then, my lord, there were orders passed with regard to how the sale is going to be conducted. So, my lord, another of his friends, Kanti Commercial, preferred an appeal. He preferred an appeal. He did not get an offer. Kanti Commercial preferred an appeal, and they managed to, my lord, get a stay of the sale. And then, my lord, that appeal is being disposed of by this order. So, my lord, both their claims are being dealt with. Yes, yes, yes. And then, my lord, can you see page 7? In so far as the claim for eyelid is concerned, there is no application for disclaimer. If the eyelid of eyelid is opened, it would show a remotest chance of establishing its rights based on an unregistered agreement. That's the first question which my lord put, my lord, to me and to my learned friend. It seems to us an attempt to create a shadow of right on the property, and in absence of any affidavit reply being filed in CA1, thereby refuting the claim of the official liquidator as to its tall claim over the property, we feel that it's another ploy to defer the sale. The ground that court should not proceed with the sale of assets in view of the pendency of the review application and may not hold ground in view of the order passed by bench president Justice I.P. Mukherjee on 10 March, which the Honorable Division observed as follows. Then that is considered. Then page 8. Honorable see fresh, because they were only hindering the sale of this property. That's why this order is being passed. Directions are given. Then page 9. We make it clear that the rights required to be decided. Page 9, 4th paragraph. Clear rights required to be decided in terms of the order dated 23rd September 2021 and 3rd February 2020 no way disturbed by this order. 3rd February, my lord, is my order. However, it will be open for Idlit and Salazar to participate. No, so his property, my lord, can he participate in an auction sale? Yes. So I am showing, my lord, that how much credence the court has given to his assertion that he owns this property of Dunlop, half property of King's Court. He's been asked to participate in the sale of my lord King's Court property. And what fell from my lord? 3rd February, or it's passed on the basis that Dunlop owns it. And my lord, there was a special petition, my lord, from this also. That was also, my lord, dismissed. That is 4th March. September.
Today.
So let him, my lord.
Yes.
Judge Sahib, জিজ্ঞেস করছেন তোমার application আগে।
Yes, yes. Anas, may I? My lord, may I? My lord, may I say this? It is the direction of the division bench. With humility, I submit, my lord, obviously, kind of does not take fairness. On 2nd of November 2023, my lord, this order was passed. My lord, if you lordship kindly sees, my lord.
This is my
কি করছো তারপরে অর্ডারটা দেখাও।
আমি তো এটা দেখাচ্ছি।
Show what has been passed later. What are you saying?
তুমি তো 19 সেপ্টেম্বর দেখালে।
না,
এতক্ষণ তো আমাকে তাই বললে।
19 December.
Yes. But that is fine. What he's showing.
What do you mean? 19 December is subsequent to November.
No, I am saying 2nd November, Malad, this was pronounced by the court.
It's an ad interim order.
Malad, no, Malad, kindly sees page 2. Keeping in view the balance, the such and such an ACO is disposed of with a request to learn a trial judge subject to the convenience of said court to take up the application bearing number C. Disposed of. Yes, my appeal is disposed of saying that pending at the BS of the present application before the learned trial judge comes and the sale proceeds.
Correct.
So what is
there was no stay of sale.
That is what is the meaning, Malad. I cannot understand, Malad. It says that my CA 83 should be. That is the one.
Not happening.
That is CA 83.
Division bench order of 19 December 2023.
True. Malad, may I say this? This is in my appeal.
November to December आगे आज.
Malad, I appreciate. I completely appreciate. Malad, kindly, no, Malad, kindly takes this order once. Kindly takes the 2nd November. It must be there, Malad. 83. Malad, 2nd November, my appeal is disposed of with a request that this application should be heard out before confirmation. Yes, that is written. Hey, that is order.
তুমি 19 December টা দেখো তাহলে।
Again, Malad, my appeal is being disposed of here. What is 19 December? That is Kanti's appeal. But that is what I was trying to say appeal now. Yes, so may I start? Has to be, Malad. Yes, today. Today I will not. If it's convenient. Any date, Malad, next week, any date.
ওখানে কিন্তু আবার আমাদের
Yes.
ওখানে আবার ফিক্স করা হয়েছে।
11th, Malad, 11th. 11th তো আমি ফ্লাইট নিচ্ছি। ফ্লাইট নিচ্ছি।
দেরি হয়ে যাবে। হ্যাঁ তাহলে 3rd করো।
Can be on the 3rd, Malad.
যবে জজ সাহেব নেবেন।
Yes, obviously. And I'm appearing in that one, yes. Malad, 168. Malad, 11th, Malad, I was a bit of a problem. That is why I was just. If it could be the 10th, Malad. Yes, yes, my kindly.
My lord, then it will. No, I am there, but it will go on, my lord.
Only this.
Will get postponed.
But I'm okay for third. I'm okay for any other day.
Then I'll get it down.
Yes. I'm very sorry, man. I do not. But that day, my lord, I have. আমি যেতে পারি না খুব একটা।
সে তো গোল মেরে ঠিক আছে
ভুল মেরে আমার
যেতে পাও না সেটা ভুল very well
ঠিক আছে
I am there,
I will be there.
Mr. Ray wants me, but
CA
83
of 2021 shall be taken up for
First.
consideration on that day.
Yes, yes, man. Definitely. I want that also.
my lord, kindly fix a time, my lord, so far as
For the first matter origin said. I don't know what we call it.
same well, my lord, same position, my lord, would mean, my lord, that will come after, my lord, all those 85. I don't know when that matter will fix.
Yeah. No matter he's saying today it is appearing as 85.
85,
Doesn't
86.
matter. Those are all workers' application. Your Lordship is hearing this first.
Kindly hear this first. Very well.
Yes, yes. Well, I did not understand why did we quarrel. Why did we quarrel? We did not. I did not understand.
No, I wanted the
I
matter
was-
to be
I
heard.
wanted-
My relevant doesn't want the matter.
I
to
was
be heard.
wanting to
That's why, my lord, we quarreled.
I
That's why we quarreled.
thought he was trying to hijack my petition.
So, my lord, our sale order was 21. I've still not managed, my lord, in spite of 2 division benches orders, my lord, with regard to.
He's Salah, sir. Why is he getting so?
And his eyelid whose eyes have been opened.
Malad, I'll get someone, Malad, with eyelids also.
Item number 88.
But I must point out one thing, because I'm obviously, Mr. Bannon should know that I'll be challenging his maintainability to appear in my matter. Yes. He's not a party, so I'll challenge that.
Then, my lord, kindly dismiss his petition because I'm not a party.
Malad. No, definitely not. I want Mr. Banerjee's quietness.
Lord, I
In
shall
this
answer
way.
him on that day, my lord. I shall answer him on that day.
Hateful, Malad.
Item number 88.
Other side কোথায়? Last time, yeah, no, my lord, this matter has a checkered past. My lord, basically a show cause notice under challenge. Three writ petitions are pending. Now they say there is already an order of provisional. Yes. Customs Act, Gold, Caesar. Caesar is under challenge in a separate writ petition. Now there is an order of provisional release by the tribunal. Rejected by the department, we went to the tribunal pursuant to a division bench order. We had obtained an order of provisional release. They challenged it in an appeal. Division bench set aside the order since the order was without reasons. Matter was remanded back. Provisional order once again passed with reasons. Now they are not releasing despite that order of provisional release. Yesterday or day before yesterday, my advocate on record was told that they have preferred an appeal from that order of provision. This is subsequently, despite Caesar is under challenge, they have issued a show cause notice. We say we were on the jurisdiction. The Caesar was without jurisdiction, only without jurisdiction. Caesar of Gold, I am a 4-star export house. I purchased gold from HDFC Bank, the authorized dealer. So this was basically the issue. Kaushik, they usually appear. I can give them one more notice and come back any day convenient to your lordship. হ্যাঁ না এটা কাস্টমস এর মামলা তো ওরা অ্যাপিয়ার করে ইদার মিস্টার দে
But he's coming up.
কে
Maiti Saraj. Kindly. Well, the Caesar was challenged, my lord, based on the judgment of a Supreme Court called Bicolodi. I'll tell you, Lordship, what had happened. I'll tell you, Lordship, my lord. Once the goods are imported, and my lord, I am not the importer. The importer is HDFC Bank. HDFC Bank imports, and thereafter, as the authorized dealer, sells gold bullion, gold bars to manufacturers. And I am an export house. I'm a 4-star export house. My lord, my turnover is in excess of 5,000 crores. So from HDFC Bank over the last financial year, I have purchased gold more than 3,000 kgs. I'm a regular. So what I do is I purchase gold from HDFC Bank. Thereafter, I process the gold, make ornaments, and then I export.
Yes. One thing, my lord, before my land. One thing, my lord, that tribe. No, no, he should not waste his time. That's why I'm saying. We have preferred an appeal, my lord. That can be taken up tomorrow or day after tomorrow, your lordship.
As he said.
Yes.
That's
No. That has, prior to that, my lord, they have prepared a writ petition wherein they have challenged the seizure, my lord, wherein the direct challenge.
Yes, pending. Writ petition is pending.
And
this court, before your lordship's court. Yes.
Direction was given to exchange
affidavit. The issue, because that would be the final relief. So that direction for affidavit issued has been given. Till date, they have not filed affidavit. Yes. Yes. Correct. Show cause. Now they've given a show cause notice. 15th of May. 15th of May.
We have given the show cause notice.
If your Caesar is without jurisdiction, where is the question of issuance of a show cause? Along with that. My lord. Previous one. That is. Yes, all annexed. Everything is annexed. I'll just indicate to your lordship. That is the confusion which has happened. No, but they cannot proceed with the show cause. Now, if your lordship will kindly see, this is I succeeded. Caesar interim order is what? Caesar was under challenge, my lord. Correct. Yes. Correct. Absolutely. Correct. Yes. Yes. Correct. No. Interim order was for release. Court said you apply. I applied.
Not stop them from proceeding inquiry and say that no further, because this further action was there.
No, but at the Caesar stage, because the Caesar was under challenge, what they can do is now, post show cause, they will start the proceeding. I am saying that at the threshold, if the first step is without jurisdiction, where is the question of show cause? Because if the provisional order has been passed, what will you proceed with?
Page 48. Page 48.
WP 1897.
Seizure. Oh, that is at page.
Yes. Well, actually, the difficulty is that the appeal and this, everything has become all mixed up. My lord, kindly takes it up on Monday or Tuesday, my lord, because the appeal court's brief with this brief has got mixed up. Because the page numbers here are not telling with the writ petition.
Tuesday.
Tuesday, very well. Monday কেন করবেন?
Monday আমার অন্য not
Monday কেন?
Yes. Not this week.
Bye. Well,
Monday. কালকে কোথায়? আজকে কোথাও আপনি তো সময় নেই। Yes.
whenever, my lord. Tuesday?
Item 89.
Please, Your Lordship, I am appearing for the petition in the matter. Lord, I had indicated section 199 of the Income Tax Act on the last day to submit. Section 199, subsection 3. My lord. Very grateful, my lord. That's the contention. Yes, my lord. Yes, my lord. And yes, my lord, because there was an arrangement between the JV and the petitioner that the JV will claim and get the amount and will remit it to us. The fact, my lord, bears credence from the act of the JV, where, my lord, the joint venture entity had treated that bank guarantee which we had given, 2.88 crores, as our investment, as our income, and that is the reason it was given back to us. It was given back by the JV to the petitioner when the purpose for which the JV was formed had failed. The allocation of coal block did not go through. The setting up of the steel plant did not materialize, and that is the reason, my lord, it was given back. So it is an admitted position that the JV treated this amount as the amount of the petitioner. Yes, my lord. There are. My lord, 199. May I first, before I place reliance? There are rules, my lord. Rules framed by the board, lordship. For the purpose of giving credit, they may frame rules. That's the reason, perhaps, my lord. Yes. Other than those, because, my lord, I am other than those. My lord, there is a rule in the Income Tax Act, 37 BA. I am handing over, my lord, credit for tax deducted at source for purpose of 199. My lord, I am handing over income tax rules.
My lord, it is for the deductor. The rule is if it is very clear. Yes, 3 is, my lord. So it will go to the deductee or the owner. My lord, the rule is for payment to the deductor. He is other than those. So it is for that. Rule is there for that. But if
income tax rules.
That rule, my lord, I don't have.
Lord, I'm handing over. I'm handing over a copy of. I'm handing over to you also. Thirty-seven B8. 37B. Not a circular. Not a circular. It has rules. This is the rule. That's the circular. That's a circular. Oh, yeah, that is referred to. Yes. Lord, may I also indicate the core correlation from the Act, your Lordship will find there is under my lord 199 subsection 3 in the Act, the second line, my lord, make such rules, and there's a footnote, my lord. That footnote refers to the specific rule 37BA. And 37BA is what I'm referring to. Two, one, where under any provision of the Act, the whole or any part of the income on which tax has been deducted at source is assessable in the hands of a person other than the deductee. So subrule 1 deals with the deductee. Subrule 2(1), other than the deductee, credit for the whole or any part of the tax deducted at source, as the case may be, shall be given to the other person and not to the deductee. I place reliance on this, my lord. Provided that deductee files a declaration with the deductor and the deductor reports the tax deduction in the name of the other person in the information relating to deduction, which has not happened. That's the admitted position, my lord. Otherwise, if this would have happened, then, my lord, the assessment order would have been in favor of the joint venture. The assessment order, now kindly may I now refer to, my lord. My lord, may I read the proviso once again with the subrule 2(1), lordship. Provided that the deductee, which is the joint venture here, my lord, files a declaration with the deductor and the deductor reports the tax deduction in the name of the other person. So that's the, my lord, the petitioner before your lordship. The petitioner before your lordship. In the information relating to deduction of tax. So if this happens, my lord, provided in the information relating to deduction of tax referred to in subrule 1, my lord. My lord.
And provides your name.
So the deductee has, kindly see the joint venture. If the joint venture, my lord, kindly consider the situation. If the joint venture is no longer,
Deductee file the declaration with the deductor.
my lord.
Deductor has to report. Deductor report the tax deduction in the name of the other person. It has to be a consequential change effected for the income tax authorities to give effect to the same.
Not when, my lord, may I very humbly submit, not when the income tax authorities take the stand that this amount belongs to the petitioner and not to the JV. It is only when the authorities take the same stand. My lord, I am placing reliance on a judgment which is exactly the same fact situation. But I think that will aid in my submission. This is the one, the Commissioner Bhutram. Commissioner of Income Tax versus Bhuratnam and Company. It is reported in 2012, SCC Online, Andhra Pradesh, 569. The 3 paragraphs are of extreme relevance, 17, 20, and 21. But before I, my lord, lead your lordship to those paragraphs, may I quickly indicate the facts here. It was with regard to a joint venture entity, my lord. Contracts, if your lordship kindly takes up paragraph 2. SSC along with 3 others, namely Koya Construction, Indian Hume, Tahir Ali Industries, entered into a joint venture agreement called so-and-so on March 12, 2003 for the purpose of preparing and submitting pre-qualification or post-qualification tender to the Hyderabad Metropolitan Water Works and Sewerage Board. According to the terms of the said agreement between the parties, each party, that is a co-venturer in the joint venture, is responsible for his respective profit and loss. Very similar case, my lord. Earned by him in the execution of each one's respective share in works. Each of the parties to the joint venture is concerned with the share of work, contract, and profit or loss arising therefrom, and the agreement was not to be treated as an agreement to earn profits only. Same arrangement, very similar arrangement. Here it was not for earning any profit. It was a bank guarantee which was given for execution of work. It is a capital expenditure there. My lord, contract receipts were offered for taxation in the hands of the firm after July 15, 2003 from all existing works contract over the page, my lord. On November 2004, the assessment year, for the assessment year 2004 and 5, for the period up to July 15, 2003, the firm filed its return of income declaring an income of this. On November 29, 2004, for the assessment year 2004-5, for the period of after July, so one was up to July, this is after July 2003, return was filed for this sum, 4 crores 32 lakhs. With respect to the contract work receipts, TDS was done, but the assessee claimed credit of the tax mentioned in the said TDS certificates. The assessing officer, in the assessment orders of both the firm and the company, refused to give credit on the ground that some of the TDS certificates belong to the joint venture and some other TDS certificates are in the name of directors and do not relate to the assessee firm or company. No, my lord. There's a reason the joint venture, yes, because what has happened here, lordship, yes, my lord.
The other facts
Are absolutely similar.
here. The premise, the SSC had asked for the refund.
The JV.
No, SSC has asked.
No, in this case, yes, my lord. Yes,
And for the name of the JV.
my lord.
Refused.
Lordship.
Your case.
It is just the opposite.
Just
But factually, the ratio is still applicable, my lord. I'll indicate why. Yes, my lord, I'll indicate why. Here, in our case, the JV. No, I understand that. I understand that, lordship. Here, my lord, appeals were filed, that's paragraph 7, and agreed by that order. Your revenue for further filed appeals before the tribunal. Tribunal heard it, passed an order, that's paragraph 9. And this rule was referred to, my lord, 37BA. Required to give credit, my lord, I'm reading out the first 3 lines of, my lord, the paragraph which starts at internal page 3. It relied upon Rule 37BA of the Income Tax Rules 1962 and held that the assessing officer is required to give credit for the TDS certificate filed by the assessee company, either in the name of the assessee or in the name of the director. It accepted the contention of the assessee that the income included in the TDS certificate has been considered for the purpose of determining the total income of the assessee, and that on the same logic, due credit should also be given to the TDS involved in that certificate. Tribunal by an order rejected the appeal of the revenue. Agreed thereby, present appeals were filed under 260A. Heard, number paragraph 13. Section 199(1) and 199(3) are referred to, my lord. Paragraph 14, the rule 37BA is referred to. Then, my lord, paragraph 15. Paragraph 15, my lord. The rules of 2011 CBDT amended the rule and the following clause was added. This amendment was done away with the specified 4 clauses in the pre-amended Rule 37BA, which restricted the benefit of the rule only in 4 specified situations. It has thus widened the scope of Rule 37BA, thereby enabling the credit of taxes to the actual payee in whose hands the income is assessable, and not restricting this benefit only to the specified 4 situations. That's the 4 situations which are referred to on the previous page. From page 3, paragraph 14. it has referred to, my lord, A, B, C, D, those 4 separate clauses. In our view, my lord, the operative portion now is paragraph 17. In our view, Commissioner appeals and the tribunal have rightly held that the SSC is entitled to credit of the TDS mentioned in the TDS certificates issued by the contractor, whether the said certificate is issued in the name of the joint venture or in the name of a director of the SSC company. So either way, that's the finding, my lord. They have considered the terms of agreement dated 12th March 2003 amongst the parties to the joint venture and held that the credit for TDS certificates cannot be denied to the SSC while assessing the contract receipts mentioned in the said certificates as income of the SSC. I pause here for a moment, but this finding, since we do not have the details of the agreement before your lordship, that this is quoted in the assessment order with approval by the department. This very part, my lord, that it is their income, it has to be credited in their name. Hence, we are refusing to give you credit, you as in the JV. Because the income shown in the TDS certificates has either to be taxed in the hands of the joint venture or in the hands of an individual co-joint venturer. As the joint venture has not filed return of income and has claimed for TDS certificates and TDS certificates have not been doubted, credit has to be granted to the TDS mentioned therein for the SSC. Rule 37B is a procedural provision. Lordship. And then the rule. Indeed, unjust enrichment. In fact, I'm carrying judgments to that effect, Lord, that this tantamounts to. Yes, my lord. And that is why the facts are different because, my lord, here the SSC had made that application, here the JV has made the application.
Information has to be given by the deductee, the authorities, for you to take very few weeks.
The petitioner, my lord, today before the court.
Joint venture.
My lord.
Also does.
My lord, 2 things to supplement.
This money.
Indeed. And my lord, there comes the issue of unjust enrichment and procedural hardship. My lord, I'll also indicate 2 more things, my lord. Procedural hardship, because my lord, today, for those years, my lord, kindly take up 2 documents that perhaps So, my lord, we have not. We have never. My lord, the arrangement was always this, that the joint venture would treat this amount as the amount of the petitioner. Any income, my lord, therefrom, which, my lord, is the TDS amount to which the credit of which is entitled, my lord, to the JV. JV would take that credit and remit that amount to the petitioner, and that is, my lord, affirmed in the assessment order. Kindly take up page 42 once. 2-3 paragraphs, my lord, of this order is very, very relevant. These paragraphs are required to be, my lord, referred to. One of the orders, there are 4 orders, I'll only refer to one because the others are similar. Page 42 of the petition. And this is the reason for the unjust, my lord, burden, the undue hardship. Page 42, kindly see the name of the SSC is the joint venture and the date of the order. It's 11th March 2022, my lord. Kindly take up page 43. The 3rd paragraph. The SSC company claimed that as the FD amount was paid by Dhariwal Infrastructure, that's the petitioner before your lordship, the interest income thereon should be treated in the hands of the petitioner, and accordingly, the provision was made in the profit and loss account and balance sheet of the petitioner. On verification of the same, it is noticed that the petitioner is not disclosing that interest income of rupees 25 lakhs in its profit and loss account. Accordingly, a further questionnaire was issued to the SSC company on 18th February 2020. The details whereof are as under, and it is quoted, my lord. The first paragraph thereafter is the quotation. That's the reply of the joint venture. So this is a factual fact-finding process, my lord. Kindly see thereafter. Subsequently, draft assessment order along with the show cause notice was issued to the SSC, that's the joint venture, intimating it to the proposed addition as under. And then the proposed addition. In the next paragraph, kindly take the next page, my lord. It is under quotation. And before that, the previous page, which is, my lord, page 43, the last 3 lines. In response, the SSE submitted its reply opposing the proposed addition and mentioned therein that the relevant case laws and the following facts, which is quoted as under. And it is the reply now which is being referred to at page 44 of the joint venture. I'm not troubling your lordship with the judgments. Kindly take up, the third paragraph, which start afresh from that page. In the instant case, this is the third paragraph. In the instant case, right from the beginning, it was a clear understanding. I pause here for a moment. This is the reply of the JV. So the JV is on record stating this. It was a clear understanding between the JV and the petitioner, DIPL is the petitioner, that all rights, including related interest on concern FD of rupees 2 crore 87 lakhs, belongs to the petitioner only. And the above fact has duly been acknowledged by both the parties in their financials. So that is an admitted position by the JV. It is therefore an income by overriding title and solely belongs to the petitioner. It is once again reiterated that similar issues was raised during the course of assessment proceedings. The assessing officer, after duly considering our submission, did not invoke any disallowance for not considering the interest income on fixed deposits. Now the finding part, those 3 lines are very, very important, my lord. The submission of the SSE, that's the JV, is carefully considered and accepted. So my lord, this is approved now by the department and accepted in view of the fact that the assessment for the immediate preceding assessment year has also been completed after accepting the version of the SSE on these same grounds. Now they cannot renege. This is a finding of approval of the stand taken by the joint venture, which supports my case. No, my lord, the SSE here is not me. It is the joint venture entity. It's not my contention. Is the contention of the joint venture entity, which is approved by the department. This stands as on date. And now kindly see how we plead our case of undue hardship under 119(2)(b). My lord, page 62. There are 4 documents for 4 separate years. I'm referring to one. The others are similar, my lord. Page 62. This document is very relevant. First, my lord, is the date. So the order was passed on 11th of March 2022, my lord. And this letter, these letters, my lord, were issued on 18th of May 2022. So within 2 months. Now, my lord, kindly see what is stated here. The first paragraph, my lord, gives a background. That's a joint venture for a coal block allocation by Government of India. So, my lord, the end entity is Government of India, for whom this BG was to be placed, my lord, for this work. For allotment, paragraph 2, for allotment of coal block, the MOC required to submit a bank guarantee to the tune of 10.27, to which the other 2 partners of JV had provided this. DAPL, that's a petitioner, provided exclusive funds for rupees 2.87 crores for FDR in the bank in the name of GCML. There's a joint venture, my lord. Paragraph 3, it was the understanding between the partners that all interest income from the FDR for rupees 2.87 crores will be for the benefit of the SSE company. There's the petitioner before your lordship. And when there will be a refund or encashment of FDR, it will go to the petitioner. Now, paragraph 4, my lord. In the meantime, during the continuance of the FDR, there was interest income as below, on which TDS 2 was deducted by the bank, which was also shown in 26A's form in the name of the JV. Now, the assessment years are indicated. Net of TDS is given. Above 26A's copies are enclosed. It may be verified from the records of the department that so far no credit, this is very important, my lord, the fulcrum perhaps of my submission, no credit has been given to either our JV partner or the SSE for any of the income mentioned in 26A's forms for any of the assessment year. Now, my lord, paragraph 5, very important. The above mentioned interest on FDR my lord. Also, my lord, paragraph, I'll only trouble your lordship with 2 more paragraphs, my lord. Paragraph 5 and subparagraph there too. Paragraph 5A, my lord, the above mentioned interest on FDR Well, this is page 63, my lord. Paragraph 5. No, my lord, only the I placed it partially. My lord, 5A I placed. Now, my lord, 5B is also relevant. 5A, may I only indicate and reiterate? The interest on FDR was remitted by the JV to the SSE. So this is important, my lord. This is the submission which I was making, that the arrangement was that they always treated this amount as the amount of the petitioner. Hence, this amount, the principal amount, was given back. It was remitted by the joint venture to the petitioner. That's an admitted position. In the financial year 15-16, accordingly, the SSE credited it in its accounts against interest paid on capital expenditure for the work in progress. At the time, it was assumed that the credit for TDS will be allowed in the assessment of JV company, GCML, as the TDS is shown in Form 26As of the JV company, GCML. That's the stand, my lord. That's the reason why we as the petitioner, did not, my lord, separately pray for this amount to be credited in the accounts of the petitioner, because this was the arrangement. Now, B, it is not out of place to state that the interest received by the SSE DPL was a capital receipt. Now, how is the treatment made is explained in this paragraph. That is why I'm referring to this, minute. As the interest receipt from FDR, which are inextricably linked with the purpose of setting up of a coal block development project. The FDR with the bank was made not from surplus funds of the SSE, but out of borrowed funds, and was for the purpose of investment too, was not for earnings, but out of compulsion arising from the requirement of the BG for allocation of coal block by MOC. As such, as per settled law, interest earned by the SSE during construction period was a capital receipt, which was meant for reduction of capital expenditure or WIP of the project. The SSE had accordingly reduced the costs of its assets by crediting the same to the interest paid during the construction period. Now, the rest of it, my lord, I'll not trouble your lordship with. Kindly take up page 64, subpara C. Here, my lord, is the contention as to why limitation would not apply. Further, as above discussed, since the interest income is not liable to tax at all, being a capital receipt, hence, my lord, that explanation of 5B. For claim of refund of the same, no limitation period is applicable under 119 of the Act. And we've referred to judgments there too. I'm, my lord, carrying a few judgments on, my lord, undue hardship to fortify my submissions on 119(2)(b). Kindly see the order impugned now on the condonation and on undue hardship, my lord. In situations, the department is required to give reasons. Here, kindly see the impugned order. There is no reasoning given. It's only that this has to be done through other process. That is not the reasoning. In fact, that cannot be the reasoning. I'll indicate why. Lord, kindly take up the one of the impugned orders. Lord, may I refer to page 127? The rest of the impugned orders are for different periods. The rest of the reasoning is the same, my lord. Page 127. My third paragraph is the report which is called for from the assessing officer, which is referred to. Paragraph 4. After going through the application of the SSE company, it is observed that petitioner had applied for credit of TDS, which was deducted in the name of the joint venture. For the assessment year, referred to, my lord. Now, over the page 128, the jurisdiction is this. In this context, the jurisdiction of the coal mines is not lying with this charge. It is not ascertainable that the JV has filed its ITR or not. Now, this is, my lord, clearly in contradiction to the assessment order, where it has been held that they have not filed it. The assessment order, my lord, proceeds on this premise. They had not filed the returns. The refund, if any, I'm, my lord, reading the last sentence of the paragraph, the refund, if any, arises, it should be the JV company which will get the refund, not the applicant company, Dhariwal. Now they take a stand, which stand is contrary to the stand taken in the assessment order, which has attained finality. Thereafter, my lord, the interest of natural justice, petitioner was given an opportunity. Thereafter, paragraph 7. Very important. The petitioner filed its petition citing the reason as the assessee company is a joint venture partner along with two other companies, of which the JV, Gonkar Coal Mines, for development of coal block allotted by the Government of India. During transactions, the TDS, now the reasoning which is missing is what I am highlighting. The TDS were deducted under PAN this, but the said TDS claimed by the above assessee stating that the said transactions belonged to us, that's the petitioner. And for this reason, credit of the TDS claimed by the above company by filing the condonation petition. Paragraph 8, it is a clear case of rectification of TDS return for correction of the name of the deductee. Rectification, where in the assessment order they say that no, you are not entitled to this belongs to the petitioner. So reason, yes, my lord, I'm carrying, my lord. I will, my lord. I'll share a copy of the judgments also. Lordship. My lord.
But I won't take much long, my lord. I have very little to submit. Lord, something on the judgment, my lord. I'll show how it is not applicable, and Lord on the rules. Nothing more, Lord, because Lord, I understand. Yes, my lord. I cannot hold on to the money. I know that. Lord, even I though I also know, my lord, that I cannot hold. I am also not in contention. He's trying to holding on to the straw by relying on this. So, my lord, even I, my lord. No, my lord. Even if he is entitled to the money, my lord, he has to come, my lord, by a process. My lord, he is entitled to it very well. My lord, I cannot give it to him, my lord, right away out of the pocket. My lord, there is an extent of formality, my lord, which has to be, my lord, observed. My lord, if that formality is observed, my lord, the order, my lord, however unreasonable the order may be. My lord, what does it say? My lord, it says that you rectify it. It is not. It is not, my lord. He's, my lord, even his prayers, I shall show it from his prayers also, my lord, that he knows that. My lord, his prayers are couched in a fashion, my lord, which show that, my lord, he knows, my lord, what are the ways out. My lord, I shall show it, my lord. My lord, Mr. Bagh is there, so he'll definitely.
Not my draft, my lord. That's the answer. in fact, not a draft. Lordship.
Lord, no quarrel to that. My lord, I have to accept that proposition, my lord, hands down. That is a settled proposition. 199.3. 3. Very interesting. But Lord, I shall make my submission. I shall make my submissions on that, Lord. No, I'm not interested.
I'm carrying judgments on that proposition also.
Yes. Lord, he is entitled, he'll get it, Lord. He has to come through a process. That's it.
In fact, I should also clarify that the draft as I've submitted is not mine. It is also not my juniors. So, my lord, it's not my juniors also. So we have to defend, but the points are all covered, my lord. So that is what, my lord.
But there are judgments galore, my lord, all to the credit of my learned friend. But then, my lord, that doesn't oust me, my lord. I'll make my submission then. But I'll want to put it on next year. Yes. Lord.
Second July, my lord. No, my lord. I'll be there before you. Lordship. Deeply obliged.
Yesterday, my lord, direct come and mention the matter. Yes, your lordship, I have sent a notice, your lordship. If my lord kindly takes it up, because tomorrow, my lord, perhaps do not take up the original side matters. Some precedents, my lord, because it's yesterday it was 45, today it is 127, your lordship, item number. Lord, some precedents within the first 10 matters, at least, your lordship, if I will. Some precedents, my lord. My lord, why I'm emphasizing so much, your lordship? First test they have conducted, your lordship, 3 months before in the month of March, your lordship. Now, after 3 months, without there being any adverse remark, your lordship, they want to conduct another test, your lordship. My lord, I am not standing on the. My lord, they might my lord knows, my lord, they might manipulate. All I am seeking is, your lordship, I am not standing on the way, your lordship. I am absolutely cooperating since the inception. The only thing is that, your lordship, let them come up and just bring the. Some precedents, my lord, gives it.